For judgment WPC 6372 of 2022 and batch of matters.
If quash the notices and all proceedings consequent thereto, this will not, however, preclude the department from proceeding hereafter in accordance with law.
Thank you, sir.
Supplementary list fresh admission item number 2. Item number 2, STR review 35 of 2015.
All right. You have for the
Item
petitioner.
3, Milan. Item 3.
So
Item number 2, sir.
none appears for the petitioners. Dismissal not possible.
One lead petition.
Both.
Fresh admission item number 3.
Milord, in this case, serious illegalities has been committed regarding selection of beneficiaries for Pradhan Mantri Awas Yojana.
You can go to the
For,
Lokayukta for these things.
Milord,
You can go to the Lokayut for these things.
Milord,
It's better to do that. They have more resources and they have more time for all these things.
Milord, now the opposite parties are releasing funds in favor of
So
some
you go,
ineligible.
you go immediately to the Lokayut, sir. It's very
Milord,
easy to go there.
Within 1-2 days, they will release. Milord.
You can go, sir. Tomorrow morning you can. The Lokayut, no difficulty at all. No court fee, nothing. Simply have to make a copy of this.
Milord, the
Representation,
huge amount
take it
of
to the
public
Lokayut.
money will be wasted, Milord.
No,
The persons who have buildings, they have selected
the
them
sooner
as
you go, the
beneficiaries.
better, sir. Then
Poor
quickly
persons
action
are
can
not
be
getting
taken.
the benefit, Milord.
All right. Permitting the petitioners to approach the Lokayut in regard to the grievances made in the present petition. It is disposed of. All right.
Item number 4.
This matter may be added to the 2 p.m. list. It's a Intratax.
Right.
Item number 5.
May I please, my lords?
Yes, please.
I do only request your lordships to kindly turn to page 35, my lord, which is my return minutes.
Yes.
And if your lordship would kindly see E18, fixed assets. At the left-hand column, at
Yes.
page 35, my lords. At
Yes.
the E18, fixed assets.
Yes.
So this is 73 lakhs, my lords.
All right.
Then your lordship may kindly turn to, my lords, the notice, my lord, which has been
So
issued
this
to
is
me.
only post 148AD, 148
my-
notice is issued. That's it.
My only endeavor, my lord, I am aware of the inevitable, my lords. But my only, my lord, humble effort would be, my lord, to bring certain situations before your lordships, where your lordship would be convinced, according to me,
All right.
that it will be merely change of opinion, my lords.
All right.
Then, my lord, so after I file my returns, my lord, on showing the fixed assets as 73 lakhs, my lord,
Yes.
your lordship may see that at page 40, I get a notice under 148AB,
Right.
and the allegation is that 68 lakhs. Your lordship
Correct.
get it, my lord.
Correct.
Then if your lordship would turn to my reply, my lord, at page 41, my lord,
Yes.
paragraph 4, your lordship would see. I categorically say that the SSC has also filed the balance sheet for the assessment year 18-19, in which the land has been shown as fixed assets for the value of rupees 73 lakhs, including stamp duty and registration fee, my lords.
Right.
In spite of this, my lord, they do not consider me. And in the balance sheet also at page 43, if your lordship would see, my lords, the balance sheet was also given at page 43, my lords.
Yes.
At the right-hand side,
Yeah. Landed cost.
land records. But still, my lord, they, in the order under Annexure 4 at page 44, the 148AD order, my lord, they do not consider it. They still stick to that 68 lakhs, my lords. They don't consider all these aspects, my lord. And then they serve a notice under 148 under Annexure 5 at page 46, my lords. My humble contention, my lords, once I have shown all this, my lords, and I have shown a higher figure of 75 lakhs, saying that this is the amount paid for purchase of land, inclusive of stamp duty and others, my lord. Still, my lord, on some information, they say it's 68 lakhs and you proceed. And so it's, in my humble submission, it will be merely a change of opinion. With 143.2, my lord, they accept my returns. Then all of a sudden they say from nowhere they get a figure of 68 lakhs and they say that you have to now face a proceeding of 140 lakhs.
Right.
And your lordships are aware of the various lines of decision. I need not at least cite your law about change of opinion before this on the bench, my lord, at least.
You say just permitting the petitioner to raise all the pleas.
Plus, may I just pray, my lord,
I'm just
this Kailash Kedia's order.
Correct.
Your Lordship has already disposed.
No,
Yes.
Kailash Kedia's order. My lord, I'll just. Oh, I'm sorry.
Yeah.
The lordship will just, if subject to your lordship's kind consideration, lordship may just note my contentions. And your lordships have also
All right.
at page paragraph 10, your lordship have of Kailash Kedia, my lord.
Correct. All right. You say
9 and 10.
all right. The challenge the present petition is to the order passed by the assessing officer under section 148 capital A bracket D of the Income Tax Act 1961, as well as to the consequential notice dated 31st March 2022 issued under section 148 of the Act. Full stop. This court has in its order dated 1st December 2022 in writ petition civil 9191 of 2022 bracket Kailash Kedia, Assistant Income Tax Officer, Ward 1, Jharsuguda bracket. In similar circumstances, following the decision of the Supreme Court of India dated 2nd September 2022 in Anshul Jain versus Principal Commissioner of Income Tax. Bracket CW SLP Civil 14823 of 2022 bracket. Permitted all the grounds to be urged in the reassessment proceedings. In the when the order passed in the reassessment proceedings under section 148 Act of the Act is required to be challenged. Full stop. Paragraph. Accordingly, in the present case as well, this court clarifies that it will be open to the petitioners to urge not only the grounds urged in the present petition, but all other grounds which may not have been urged before this court and which may be found necessary to be urged at the appropriate stage in accordance with law. And then para 11 and 12.
10, 11, 10, my lord.
10 I've now dictated of 10. So
Because there your lordships have granted us liberty to, my lord, again, if necessary, my lord. Paragraph 10, my lords. We stick to that.
I've actually paraphrased this whole thing now. I've done it. When you read this order.
How to clinch the straw, my lords. Let them
No, I think you're already to create a wedge in the Supreme Court.
But in a reply, kindly verify.
Sorry, my lords.
In your reply,
My lords.
kindly verify 41, page 41.
Page 40.
And that is reflected in the assessment
My lords.
order.
Order
148
43.
also.
But they don't consider that.
No, 68 lakhs you have yourself admitted.
No.
it is
At paragraph 5,
movable asset. In a lighter way,
no, my lords.
it has no impact.
Lord, I am always welcome.
No, that is what he has reflected in his order.
My lords.
148.
But it's always my humble attempt to hear to your lordships, my lord, and take all advices in the right spirit.
My lord, on a lighter
It
note,
reminds us.
Justice Paul once said in court in one of the
28
Orissa matters that if you couldn't persuade Justice Muralidhar, then bad luck.
With great respect to my learned AG, my lords, we have been successful in most of the times.
Yeah.
We fail. And failure is a part.
That's true. That's true.
Item number 6.
Item number 6, my lord, I just would like to draw your lordship's kind attention to the CBDT circular, my lord. After Lord Ashish Agarwal's case, my lord, your lordships have already gone through the CBDT circular dated 11th of May 2022, my lords. Your lordship may kindly see. Please. Here it is less than 50 lakhs, my lords. That would be my attempt, my lords.
Nice.
That's, your lordship would kindly see. And I'll just take your lordship to the facts briefly, then your lordship my learned friend can have that opportunity of reverting my
Instructions.
reply.
Ah.
47, at page 37, my lords, annexure 2. Lord, a notice under 148 was issued, my lord, on 20, for the assessment year 16-17, dated, your lordship got it at page 37, my lords.
Yes, yes.
For the assessment year 16-17, it was issued on 21st of June 2021, my lords.
Right.
Thereafter, my lord, after Ashish Agarwal's case, my lord, annexure 3 at page 38, a notice under 148B was issued, my lords,
Right.
on 27/5/2022, my lords.
Right.
And if your lordship would just turn over the page, my lords, at page 40, and in bold letters, my lord, your lordship may just say the
Yes.
total amount is 20,25,275 for the financial year 15-16, my lords.
Right.
Yeah, I'll just stop at that. I'll take a lordship's to, my lord, the CBDT circular, my lords. If your lordship would kindly turn to paragraph 6.1, my lords.
Just come to para 4 at page 48.
Lord, page 48, my lords.
Para 4.
My lords. Para 4, my lord, however, no explanation to the said communication has been received. No, that is not correct, because earlier, my lord, your lordship would see at the top, my lord, he's extracting at page 48, 20,25,275.
No. What he's trying to say is,
Any explanation he says, my lord. But I have already explained, my lord. Your lordship would see, my lord. I have an annexed at annexure 4 at page 41.
pursuant to the show 148AB.
VAB, my lord, I have given a reply at annexure 4 at page 41, my lords, where I have also quoted the CBDT circular, my lords. Page 41, if your lordship would see.
So then how did this factual mistake happen?
And the entire,
That they have also given instruction, my lord, I'll file counter in this case. My lord, they have denied, he has not submitted any explanation to that for that. my lord.
That annexure 4 is 29th May.
That is apparent, my lord, that is filed along with the repeats, but categorically they have denied.
Mr. Kara points out
submission of
that
any-
statement in the para 4 of the impugned order dated 28 July 2022, passed by the ACIT's Rourkela Circle, that the petitioner did not reply to the letter dated 27th May 2022 of the department is factually incorrect, since the petitioner had in fact submitted such a reply on 29th May 2022. So the second point urged is that
the
the
information value.
department is not taken note of the instruction number 1/22 dated 11th May 2022. And in particular, para 7.1 there, paragraph. On both these aspects, you said a notice on both these aspects, Mr. accepts notice, states that he will file a counter affidavit within 4 weeks, rejoined for the next date. Now we'll have to say that they can proceed, but no final order will be passed. Same thing. The proceedings may continue, but no final order be passed in the next date.
I just plead for no coercive action. That is the usual order, your lordship.
No final order is more than enough, sir. No demand. can be
Why,
raised
my
then.
lord, why do we face a proceeding, my lord? If the information value, my lord, I'll only, my lord, humbly repeat myself, my lord. If the information value is 20 lakhs, your lordships are already seen the circular, my lord. It can't be 50 lakhs. It has to be 50 lakhs and more. Because what has happened, my lord, if they are following the new provision, my lords, 149, my lord, they have quoted, my lord, the CBDT has quoted 149 for a moment, page 2, my lords. At the second page,
Correct.
no notice under 148 shall be issued for the relevant assessment year if 3 years has elapsed from the end of the relevant assessment year, unless the case falls under clause B. Then even if your lordship would take the extended period, my lord, if 3 years but not more than 10 years have elapsed from the end of the relevant assessment year, unless the assessing officer has in his possession books of accounts or other documents or evidence which reveal that the income chargeable to tax represent in the form of asset.
He will file a reply to explain how this is satisfied.
50 lakhs, my lord, I am harping on this 50 lakhs.
No, I've noted that.
May I just humbly repeat, no coercive action.
No final order will be passed. That's more than enough, sir.
Greatly obliged.
List on. August 17th.
Looks good. No,
Item
may I
number
just submit,
7.
Prem Lord, while they are deciding, they can also take this information value of 20 lakhs. They will also consider that part.
Well, fine.
No, they'll file a paravis reply.
Your lordships have permitted them to proceed with the assessment, but no final orders to be passed. While proceeding, my lord, they'll also consider this monetary.
Obviously, will otherwise Mr. Kare will have one more ground.
But I may not have the good opportunity of arguing before the song.
No, you will. You've got so many matters in the pipeline.
Greatly obliged.
will be deprived.
Greatly obliged.
All right. All right.
Item number 7.
May it please your lordships, for the financial year 12-13, the assessee, who is an hospital and is represented through the managing director, who is a endocrinologist, could not deposit the TDS collected from the salaries of the employees as well as the doctors, consulting doctors. Now, my lords, a prosecution was launched. Then, in order to buy peace, I filed an application for compounding. Lordship will be pleased to see Annexure 2 at page 22. An application was filed with all the requirements for be eligible to get the compounding. That is Annexure 2, page 22, my lords.
So that's been rejected.
That has been rejected under Annexure 1 solely on the ground that limitation. Now, so far as the limitation is concerned, the Honorable Supreme Court, my lords, had extended the period of limitation. That is 8 and 9, lords will find. And the learned commissioner, he has not mentioned about that. And even though he has come to this order of the Supreme Court, which has been exercised under Article 142, this has come to his knowledge. That is the thing, my lords. Excepting on the ground of limitation.
Order was passed, your lordship, see 11/11/2022.
That's right. No, they're not the limitation calculation.
Limitation. Filing of I have filed it in August 2021.
That period COVID is there, my lord.
Yes.
The date of filing.
Yes.
Kindly see the order passed, but he has not filed within the time of the order.
That is a guideline.
Yes, yes.
That is the guideline. Guideline came in 2019
That
and
guideline.
2022. Guideline, which says that 12 months and
Yes, yes.
24 months.
That is what reflected in the order, your lordship, see.
Yes. But you have not taken into account the Supreme Court guideline.
You have not placed anything.
You
have not placed in
law laid down by the Supreme Court is
kindly see.
that is the law, and it is under Article 142.
1 minute.
Well,
See, what could happen is neither the SSC nor the commission is aware of Supreme Court order.
Lord, therefore,
Yes.
I take instruct. I'll be back to your lordship next week.
Send it back.
no, I'm sent back.
They don't
That's
have
it.
power, your lordship, see the.
No, no,
Uh,
we'll set it aside and send
Yes,
it back.
yes. Set it as a lordship may set it aside and let him
He may
consider
genuinely not have been aware.
in the light of this judgment of the Supreme
Alright.
Court, my
You
lords.
say the only ground on which notice he accepts notice. Say the only ground on which the petitioner's application for compounding has been rejected by the Principal Chief Commissioner of Income Tax, Bhubaneswar, in the impugned order dated 11/11/22 under section 279(2) of the Income Tax Act 1961, is that the application for compounding was filed beyond 42 months from date of filing of the complaint, that is 6/2/2018. Full stop. The impugned order notes that the restriction regarding limitation could be relaxed in deserving cases where the application is filed beyond 12 months, but before 24 months from the end of the month in which the complaint was filed. Full stop. What was perhaps not noted is that the said CBDT guidelines dated 14 June 2019 stood automatically further modified, as far as the period of limitation is concerned, by orders of the Supreme Court of India
Enclose,
one-
enclose in the petition, Lord. Start from space 76.
76 to
dated 8th
86.
March 2021 and 23rd September 2021. In miscellaneous application number 665/2021 in SMW bracket C, number 3 of 2020 bracket in recognizance for extension limitation bracket in the wake of the COVID-19 pandemic. Paragraph. It is possible that said orders of the Supreme Court were not known both to the petitioner as well as the principal commissioner, principal CIT, and therefore were not taken note of while deciding the application for compounding filed by the present petitioner. Paragraph. On the above short ground, the impugned order dated 11 November 2022, passed by the principal CIT, is hereby set aside, and the petitioner's application for compounding is directed to be considered once again by the principal CIT in accordance with law. The matter will now be placed before the principal CIT Bhubaneswar on 5th April 2023 at 11 a.m. when the petitioner will appear through an authorized representative. Will stop after hearing the petitioner, an appropriate order, reasoned order on merits be passed within a period of 1 month thereafter. The court clarifies it has not expressed any view on the merits of the matter.
Item number 8 is also same. Same. Only here the financial year is 12-13, that is financial year is 13-14. So the assessment is 14-15.
Or 8 also, same order.
Much obliged.
Right.
Much obliged.
Item number 9.
Milods, item 9, Milods, is covered, Milods, by that 148A order. Similar order, Milods, I have given.
Right.
Milods 9 and 51.
All right. 951.
And Milods, connected to 9 is another writ petition which has not come out today. If you not, yes, Milods, I have.
So the other one taken on.
I have
board is that-
intimated about the same to the learned senior standing council
Yes,
also.
my lord, I am appearing in all the cases.
All right.
Item number. Item 10.
No instruction, my lord.
No instruction disposed.
In this case, I am appearing, my lord.
Item number 11.
Milods, item 11 on behalf of the conducting council on Passover.
All right.
Item number 12.
Lord, 12 and 13 is same, Lord. Yesterday, Lordship passed order on IT number, serial number 18.
All right.
Yesterday list.
What
Similar.
happened? What has happened?
The Lordship dismissed the, yes.
18. Yesterday is 18.
Yes.
Both 12 and 13. All right.
Continuation of delays there also.
The delay is conduct. Right. Correct.
Item number 14.
What's the delay, sir?
The question has been framed at page 7.
Sir, 178 days delay. The delays. This is a COVID time or what?
Is there a good case for admission?
No, is it a COVID time?
Yes.
I
filed, I also delayed.
All right. All right. In view of the delay being on account of the COVID-19 period. It's condoned. Now, what's the question?
Yes.
Eligible for grant of 1023C.
Yes, my lord. Yeah.
It is having both educational and non-educational.
My lord, tribunal order is very important. Here, your lordship on page, running page 18, page 8 of the tribunal order. Principal CIT primarily declared that amended trust did. It is 26/3/2012, whereby all the non-educational objects have been related as invalid by relying upon the clause number 27 of the registered trust deed dated 19/11/1997. Principal CCIT further relied upon the decision rendered by the Honorable Supreme Court in the case of CIT versus Kamala Town Trust, wherein it is held that the trust deed could be rectified through a competent civil court under the relevant provision of Specific Relief Act, or by a settler himself by executing a supplementary trust deed. Clause 27 of the original trust deed dated 19/11/1997 says that the permanent trustees have the power to add, alter, amend any of the clauses mentioned herein for the advantage or benefit of the trust. Now, my question before Lordship is that also at page 7, whether in the fact and circumstance of the case and in law in the appellate tribunal order not perverse in holding that the SSC trust is eligible for grant of approval under section 1023C6 when it is having both education and non-educational clauses. Whether in the fact and circumstance of the case and in law is the appellate tribunal is correct in allowing the SSC's appeal for grant of approval when the permanent trustee of the trust have the power and authority to undertake the activities other than educational, could dilute an exclusive pursuit of educational purpose. Whether in the facts and circumstances of the case and in law is the appellate tribunal is correct in allowing SSC's appeal for approval under section 1023C of the Act and not considering that the trust was collecting over and above the prescribed fees and the surplus is a regular feature. And 4, whether in the fact and circumstances of the case and in law is the appellate tribunal is correct in not considering that the permanent trustee reaping personal benefit of earning rental income and advancing loan to the trust for earning interest income. My lord.
So come to para 7.2, page 36. Page 36, para 7.2.
So there is further no issue as per the learned coordinate bench discussion that the SSG held in fact set up education institutions in their 1999, imparting education in various recognized colleges, namely Ronald Institute of Computer and Management Studies, Ronald Supriya Junior College, Ronald Junior College, and Ronald Institution of Technology. Coming to the assessment here before the SL 20556 and 678 to wrong 1213, the SSG is placed on record its corresponding income and expenditure in accounts indicative figure or application of income assessment here so and so respectively. In other words, all these assessment here except 11-12 have been more application than receipt, since there is nothing left up to the considering accumulation, revenue expenditure, and the development head in the SSC's case. Relevant records indicate that 11-12 positive figure is 5 lakhs is indeed less than the permissible 15% limit of gross receipt of 8 crores 20 lakhs 08 coming to 12 lakhs 30,000. We thus observed that the SSC is applied and has utilized the gross receipt only for educational purpose as per the details evidence forming part of the case file.
So come to para 7.4 now.
4.
Page 38.
The issue therefore arises for our education in view of the foregoing pleading is as whether the clinching statutory expression employed in section 1023C6 existing solely for educational purpose has to be read in isolation or in complete sense, that is any university or college existing solely for educational purpose and not for purpose of profit. In our considered opinion, we ought to read this statutory provision as a whole, only that in that piecemeal. This is for the reason that the legislature has itself made it clear that the institution concerned has to exist only for education, not for the profit purpose. We wish to repeat that the department in such cases has to pinpoint the material against taxpayer before us, which could suggest even an idea of material fact that is never existed for deriving profits or the objects clauses reveal such as element therein. The latest judgment is there, the New Noble Education Society versus Chief Commissioner Income Tax, Supreme Court of India.
That is prospective. So that you cannot. On the other day, we have already examined this.
Then
and here also the answer given by the learned tribunal is only for the purpose of.
Yes.
So new noble, if you apply, that also clarify.
Then at page 41, 7.8 also says in our argument. Lastly comes to the revenue concluding argument that the CCIT has rightly held the SSG trustee had unbridled power and that also received payment from the former. You make it clear that there is no such condition in section 1023(6) of the Act, that the internal day-to-day running of an institution set up solely for carrying out educational activities. Honorable Apex Court Decision Commission on Custom Imports versus Dilip Kumar and Company has settled that the law is only stricter interpretation needs to be applied both in taxing as well as the deduction provisions. coupled with Mr. Tulsian pointed out that it was only for the assessment year 1 and 2 that both its trustee has sold lands to the assessee a collector rate only and as per the fair valuation adopted by the SRO Ganjam district in Odisha. No benefit or advantage accrued therein in favor of the said to a trustee, which could distinguish the important claim of the section 23C approval. The very factual position continued regarding interest paid to the said trustee as well as assessment of 7, 8, 9, 10, 11, 12, 12, 13 at the 11%, 18%, as against that the State Bank of India has paid. Then next, for 7.9, Mr. Gautam, our department concluding arguments ought to highlight the fact that SSC have paid rent as well as its twin trustee in the included assessment year, which deserve to be taken as an undue benefit. The said rental payment are found to be 1.87 per square foot and much less than the paid to the unrelated party, that is Sushil Kumar at the 220, assessment 256 and rupees 2 per square foot 267, which thus decline all the revenue argument, alleging that the SSC twin trust have derived undue benefit from the education activities carried out in all this assessment year. The CCIT all implement order under challenge in first set of 14 appeal, except are held as not sustainable in the eye of law. The same stand reversed therefore. These two SSC corresponding appeals seeking section 1023(6) approval are allowed as necessary corollary order accordingly. Then last is page 58, paragraph 14. On the other hand, the learned DR relied on the orders of the revenue authorities. The learned CIT submitted that the order has been passed by the learned AO within a stipulated time. In this regard, he referred to the provision of 153 of the Act for the this is allowed by the appeal department.
Yeah, but anyway, your grounds of appeal are not on that.
Yes. 14 appeals are allowed, 3 appeals are in our favor.
Correct. No, these appeals of yours are only on 1023C, sir, not on anything else. Your appeals are only on 1023C.
Yes, yes.
These appeals by the revenue are directed against the common order dated 15th February 2021, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack bracket IT80, in a batch of appeals by the respondent SSC. For various assessment years, bracket AYs, from 2005-06 up to 2012-13. Questioning proceedings, questioning the orders of the Chief Commissioner of Income Tax, bracket CCIT. No, denying approval under section 20, bracket 23, capital C, bracket Roman small 6 of the Income Tax 1961, bracket Act. The SSC admittedly is an educational and charitable trust. One of the grounds on which the aforementioned approval is denied was that in terms of the amended trust deed executed on 26th March 2012, certain objects alleged to be non-educational were deleted. The question was whether the appellant whether the SSC trust was an institution, open quotation, existing solely for education, eligible for exemption under section 1023 capital C bracket small Roman 6 of the Act, and not for profit. Question mark. The ITET has in the impugn order analyzed the documents placed in record, including the accounts of the SSC. And concluded that, open quotation, the SSC has applied and has utilized its gross receipts only for educational purposes, as per the detailed evidence forming part of the case file. Full stop, unquote. Paragraph. The department disputed the SSC's claim that it had not undertaken any activity other than for educational purpose since 1997. Stop. The department sought to contend that the amendment to the trustee indicated that the emphasis was on non-educational activity. Full stop. Paragraph. In repelling the above contention, it was observed by the ITET in para 7.4 of its impugned order as under. Reproduce the whole of 7.4, pages 38-39. Paragraph. Regarding the excess fees collected from the students, again, the ITET was not impressed with the stand of the department and came to the following factual conclusions. Take from para 7.7, page 40. For 5 lines from the top, open quotation, we see no substance forthcoming in revenues foregoing argument. Full stop. From there till the end of the paragraph. The ITET also negative the revenue, the department's contention that the SSC's twin trustees, open quotation, have derived undue benefit from the educational activities carried out in all these AYs. Full stop, unquote. Correct. Having heard Mr. Chimanka, learned senior standing counsel of the department, and having carefully perused the orders of both the CSC bracket D dated 26 March 2009 and the impugned order of the ITET, the court finds that on a factual basis, the department was unable to contradict the plea of the SSC that it had fully applied all its earnings Only for educational purposes. Full stop. The reasoning of the tribunal in para 7.4 of the impugned order deserves acceptance for its interpretation of section 10 bracket 23C bracket 6 of the Act. Full stop. The said paragraph reaches under. Reproduce the whole of 7.4, bottom of 38, top of 39. Paragraph. Consequently, the court is unable to discern any substantial question of law arising from the impugned order of the ITAT that calls for interference. That calls for a decision by the court. Full stop. The impugned order of the ITAT does not call for interference. Full stop. These appeals are accordingly dismissed. So the same order up to 26, correct, sir?
Yes.
Right.
Item number 26.
Everywhere delay condoned in all matters. All right.
Supplementary list item number 27. Item 27.
Item 27, one passover. On
All right.
Thank you.
Item number 28.
My please lordship. Unauthorized to occupy the government land, my lord. My representation pending, opposite party number 4, annexure 4 is pending, my lord. Similar order has been passed by this honorable court, my lord.
All right. The petitioner's representation, bracket annexure 4, shall be examined by the Tahsildar Attabira.
My lord. Yes, my lord.
And after notice the petitioner and opposite party number 5 and giving the hearing, the reasoned order should be passed not later than 1st May and communicate to the parties within a week thereafter. The court clarifies it is not expressed in the matter. Lordship, the petition is disposed.
Item 29.
My lord, similar, my lord. 29, 30, 31, 32, my lord.
All right.
Obliged.
Item number 33.
May I please, your lordship? The opposite party number 3, my lord, issued an encroachment case under by the annexure 1. As per your lordship direction, in earlier the village, the temple has been constructed in the suit plot of the petitioner, man.
So this all you have to file a civil suit, sir.
In the meantime, as per your lordship's direction, without demarcation the land, they have issued the encroachment in though the temple has been constructed in my plot, my prayer before lordship only direction may be given. They have initiated proceeding. If I have illegal constructed the land, then the opposite party directed to initiate. Before initiation of proceeding, the demarcation the land, whether I have encroached the land or not. My predicament before lordship, only this is my prayer before lordship.
You'll have to go to a civil court, sir, to establish all this. Ultimately, you have to go to
and your lordship's earlier your lordship's direction, though the opportunity has been given to the petitioner before taking any action, no opportunity has given. When the encroachment case has been initiated, thereafter I made an application before the collector, my lord. Also, that has been pending before. My prayer before the lordship authority, demarcation may be made, and thereafter you initiate the.
There's an encroachment case pending. So let him pursue there.
Yeah.
That encroachment case number 145 of 2022-2020.
An encroachment case number 145/2022 is stated to be pending before
Tahsildar.
Tahsildar Attabira.
Yeah.
No, this is Tahsildar Kanika.
All right.
Kanika.
District Kendrapada. Full stop. Apart from the fact that petitioners can pursue the remedies available to the petitioner in those proceedings, the petitioner can also independently approach the civil court for establishing the rights, title, and interest to the petitioner in the property in question. Stop. Granting the above liberty, the petition is disposed of.
It is Kanika or Rajkanika?
Yes,
ROR shows it is Rajkanika.
yes, ma'am.
Good. Rajkanika. Tehsil is Rajkanika.
Rajkanika or Kanika?
Rajkanika.
Ah,
Item number 34.
I file a mistake still the no coercive action shall be taken.
it's all over, sir. No
Now
question.
they have,
Item 34.
The other proceedings you can seek appropriate interim orders.
they have demolition the.
Yes, yes. 34.
Item number 34.
Kindly 1 week time to remove the defects, my lord.
What's the prayer? Rehabilitation benefits. When was this displacement? When did it take place?
The award is passed in 2008.
Ah,
Kindly pass over.
why are you coming so late, sir?
Kindly pass over my lord's in.
All right.
Item 35.
My lord, I am challenging inaction of the OP number 3, my lord, who is not taking initiation for initiating early proceeding, land encroachment proceeding against OP number 4, who has been encroaching government land. I have also sent it through registered post and prove it page 18, my lord. And page 24 is the endorsement regarding receipt.
All right. The petitioner's representation. Bracket annexure. 3 series.
2 series, my lord.
All right. 3 also is that. Anyway, 2 series will be examined by the Tahsildar.
My lord.
Baliapal, District Baleshwar. And after notice to the petitioner as well as opposite party number 4 and giving them a hearing, the reasoned order shall be passed not later than 24th April and be communicated to the parties within a week thereafter. The court clarifies it is not explicitly.
Item number 36.
Oblige. May please, your lordship, my lord. Plot number 2302 of under Khata number 703 of Mauja Balipatna is a gochar land, my lord. This land has neither been deed reserved nor has handed over to the Gram Panchayat. But the Sarpanch of the Gram Panchayat, Balabhadrapur Gram Panchayat, is constructing a mandap over the said land, which is not at all permissible. We made the representation to the collector.
All
No
right.
action
Petitioner's representation, bracket
The
annexure 2.
representation doesn't have any endorsement. So I don't know if it's.
There's no such endorsement, correct?
Endorsement.
You've delivered it to collector. It's not clear, sir.
In the grievance cell, I have delivered. In the grievance cell, I have taken that aberment, my lord.
But there's no stamp, nothing, sir.
That
The
grievance cell, my lord.
also gives a receiving. The grievance cell also gives a
And
receiving.
if it is 20th January, you're not even waiting for a month, sir.
Now, as they are going to construct, therefore I have come, my lord.
So you have to wait.
Let
some
that
time.
collector take an action, my lord, on that representation, my lord.
No, but you have not shown that you've delivered it.
Delivered in the grievance cell by meeting the in the chamber of the collector.
No, you have to get an acknowledgement.
That endorsement they have not given, my lord. I have
Afraid-
taken that stand also. In
It's
my
all right.
representation.
Permitting the petitioners to make a fresh representation to the collector and on
Yes.
following up on such representation to seek appropriate remedies in accordance with law, the petition is disposed.
Item 37.
May I be permitted, my lord, to rectify the defect within a 1 week?
Today is only the 11th day.
No, no, no. Please, I'm not entertaining this. Certainly not. You see, the petition is based purely on paper publications. And the investigation of the case is still underway. At this stage, the court would not like to entertain the present petition. The petition is accordingly disposed of.
Madam, with liberty to approach that, my lord, after that investigation.
We have said that, sir. Whatever we said, we said. At this stage, we have said. All right.
Item 38.
May please. certain documents of the petitioner were seized on 17/5/2019, my lord.
Copy not.
No, it's a central.
sorry.
Central. So my learned senior friend, my lord, he's appearing. So if your lordship would kindly turn, my lord, to annexure 1, my lords, at page 13.
Seizure list.
Seizure, my lord, this was seizure was conducted on 17/5/2019. Then in 12/4/2021, my lords, I make a prayer that either you return my seized documents or you grant me certified copies thereof, my lords. Till date, my lords, neither the certified copies nor the documents have been returned to me.
What is the reply?
My lord, sorry, my lords.
What have they said in the reply?
No, in the reply, they say that a show cause notice will be issued and so it can't be returned.
This is not will
Annexure
be
3,
issued, meaning when?
Annexure 3, notice for conducting audit. He has not appeared before the.
But you still have to go ahead and finish your investigation, issue the show cause notice.
My specific
You
stand.
can't endlessly just keep on holding on to the documents.
Let the document be given.
Sorry?
Let him apply.
I've
He
already
has applied.
Well,
That's how he's come to this court, sir, after not getting any response.
Then Annexure 2 may kindly be considered by the department.
You do one thing, you scan all that you've seized. You keep for yourself a digital copy, give him the originals. He'll give an undertaking that as and when you need the original, he'll produce it. That's simple. You say certain documents were seized. Yeah, certain documents were seized from the petitioner at the time of a search operation, is it?
My lord.
On 17th May 2019 and till date. And the full stop, these includes books of accounts. Full stop. Neither have the documents been returned to the petitioner, nor has any show cause notice yet been issued. Full stop. It is in those circumstances the present petition was filed for a direction to the opposite party number 2, that is the Superintendent of CGST and Central Excise, Rourkela, to return the documents seized to the petitioner. Paragraph in reply, while there is a discussion on the merits of the matter, it is simply stated that open petition documents shall be returned after issuance of the show cause notice, unquote. It is obvious that despite more than 3 years having elapsed after the seizure of the documents, the department is yet to conclude the investigation and issue a show cause notice. Full stop. The petitioner cannot be made to wait endlessly, awaiting the issuance of such SCN. Full stop. In the circumstances, the following directions are issued. 1, the department will digitize, that is, prepare soft copies of all the documents / records seized from the petitioner and keep with itself a verified and digitally signed file containing all the soft copies. Full stop. 2, the above exercise will be completed within 4 weeks. And on completion of such exercise, the department will return the original document seized to the petitioner upon the petitioner furnishing an undertaking by way of an affidavit to the department that the petitioner will keep such documents with itself in safe custody and produce such documents as and when produce the said original documents as and when required by the department. The above exercise be completed. The entire above exercise be completed within a period of 8 weeks from today. Paragraph. The petition is disposed of.
Second item, Lord, is the same, Lord.
Same, is it? All right.
The same date of seizure and my application also 12/4/2021.
All right. Same order, 39.
Much obliged.
All right.
Item number 40.
None appears dismissed.
Item 41.
May I please, my lords? This is not a case, my lords.
Your Lordship, on the last occasion, your Lordship was directed to take instruction regarding the pendency of the appeal, your Lordship. And your Lordship, the appeal is pending. So your Lordship may fix a time bound for disposal of the appeal, what my learning CD also prayed. So
Yes, sir. Your lordship specifically wanted my friend to take instruction on the basis of one judgment which I have given to your lordship in case of only cotton mill versus appellate joint commissioner. But the question arises for lordship to consider under section 107, read with 108 of the GST rules, Lords, that the appeal is to be filed either electronically or manually, as may be notified by the commissioner, Lords. Your lordship specifically wanted my friend to know.
I kindly turn to the prayer. Your lordship, is prayer is will be allowed. Your
no
lordship.
notification by the commissioner. Here, Lords, admittedly, appeal was initially filed electronically. Since snatches developed, it couldn't be acknowledged. Subsequently it filed manually, and both are within the stipulated time, within time. And of late, the department now has issued GSTR APL 2, that is the statutory acknowledgement. In supplement, those complaints are made when initially provisional acknowledgement is given, and after original order and all compliance is made, then acknowledgement APL 2 is to be issued. That is now has issued. You also kept on record. On the last occasion, I gave it to lordship. Thereafter, your lordship wanted to know, and it was not traced out. Now, next year, your lordship will find another communication. They say, now, second question arises, your lordship, jurisdiction. There are three situations arising. One, my lordship is saying that it is available, it can dispose with a time bound. That's fine, my lordship. Second is, who will be the appellate authority, my lordship? This is a case. Interception took place at Kumarmunda, Raurkela, which is under Sundargarh range. Petitioner is a registered assessee in Rairangpur under Mayurbhanj. And the intercepting officer, that he is the enforcement officer, enforcement unit, Raurkela. So, now the question is, under the Act, notification is there, which I have annexed at page, notification is there, notification, annexure 10 at page 48. There are certain appellate ranges, and the enforcement officer who has filed, there is no enforcement range for enforcement officers. Now, your lordship may kindly ask me to my friend to
no,
wherever. It can either be disposed of at Raurkela or the place of jurisdiction of the assessee where he carries on business. So either of the two it can be. But now the acknowledgement is issued in APL 2.
No, it's now pending in Baleshwar, sir.
Your lordship, Rairangpur. That the entire brief has been transferred, your lordship. And also,
so let him decide the appeal within a time bound limit.
So Baleshwar range, no?
Your lordship.
Baleshwar range.
Where it is situated. And also prayer is also to dispose of the appeal, your lordship.
That is my prayer.
Mr. Sunil Mishra, learned standing counsel of the department, has handed over a communication addressed to him dated 8 February 2023 of the Joint Commissioner of CT and GST bracket law, stating that the appeal petition filed by the by the petitioner is pending before the Additional Commissioner of CT and GST bracket appeals, Baleshwar range, Baleshwar, for disposal. Stop. It appears that the papers in regard to the said appeal have been sent to the said Baleshwar range by the Raurkela range. Although the letter states that the documents are yet to be received, Mr. Mishra states that it will be received very soon. He states that the Additional Commissioner of CT and GST appeals Baleshwar range, Baleshwar will inform the petitioner at least 1 week in advance of the actual date of hearing of the appeal. Full stop. Thereafter, the appeal will be disposed of in accordance with law as expeditiously as possible, preferably within a period of 3 months of the hearing. Full stop. No further directions are called for at this stage. The court clarifies it has not expressed any view in merits. The petition is disposed of.
Item number 42. Taken up next week. I'm suffering from fever, illness. They are pending the penalty, my lord.
What is annexure? Why have you challenged annexure 3?
Right, it was intimated after annexure 2, my lord. Now inform the my lord, opposite party, my lord, to submit the records, my lord, at annexure 2. Thereafter, they are given the intimation at annexure 3, my lord. If it not appear on annexure 3, then it will be set expecting, my lord. Because that video conference, my lord, could not be held, my lord, due to net problem. So this order was passed, my lord.
No. Is it an order? This annexure 3. Annexure 3 is not an order. What are you agreed by in annexure 3? I'm not able to understand. It's just an intimation email saying that hard copy is not received.
Yes, my lord.
No, that is your letter, is it? What is annexure 3? I'm not able to understand. Whom is it addressed to? Annexure 3.
But addressed to, my lord, the petitioner company.
No, by whom?
By the, my lord, the superintendent of, my lord, GST and Central Excise.
No.
Yes, my lord.
This annexure 3 is not from the GST. Thanking you, regards, says AGM infrastructure. No?
That is annexure 2, my lord. Wrongly it have filed, my lord. Annexure 2. That is my lord, intimation dated 25/11/22, my lord.
So wrongly typed as
Wrongly,
annexure.
yes.
Oh. You're charging annexure 2.
Yes, my lord.
Yeah, it's only an intimation. You're requested to give your consent for mode of video conferencing.
Yes, my lord.
Oh, how are you agreed with this?
No, in fact, I'm
Fix a
challenging.
date for hearing and you're unhappy with it.
I'm not, my lord, because of that. In fact, I'm challenging annexure 1, my lord.
No, but you have to appear. You have to pass an order on it, sir. Premature. We say the challenge to the demand notice dated 25th March 2022 by way of the present petition is premature since all that has happened pursuant thereto is an intimation to the petitioner by the Rourkela Commissionerate requiring the consent of the petitioner for virtual hearing. Virtual personal hearings.
Yes.
Stop. With the proceedings still ongoing and no order having been passed as regards the demand notice, it is premature for the petitioner to come to this court for relief. Stop. Permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage. And if so warranted in law, the petition is disposed of.
Item number 43.
Appearing for opposite party number 1 to 4.
My lord, item 43, my lords. On the petitioner supplied the goods to Messrs. MS Patel, your lordships. Messrs. MS Patel
against first appeal order, your lordship may admit this matter.
All right. So the 10%, 20%.
My lord, I have deposited the entire tax, your lordship. This is the order against first appeal, your lordships.
For the petitioner states that he's already deposited the entire tax. Consequently, it is directed that during the pendency of the present petition, no coercive steps will be taken against the petitioner. The IA is disposed of.
My lord, no IA is there, my lord.
Oh,
no demand is there. Your lordship.
My lord, this is an order against 129, your lordships. My submission that the order of order section 129 cannot be possible. My lordship, can we glance to page 47, my lords? Page 47.
Anyway, notice has to go, sir.
My lord. Oblige.
Notice, he accepts notice to reply within 8 weeks.
I'm for the OP2.
11 September. All right.
Extra copy may be obliged, my lord.
Item 44.
44 against the cancellation of RC, my lord, under GSTF, and the similar order already passed by this honorable court in several matters. The restoration of RC
Subject to paying all tax, interest, penalty, everything.
Yes, my lord.
Same order in 44, 45 also.
No, 44.
No, your lordship, only 44.
Only 44 order.
45, my lord, it is against a first appeal order, my lord.
All right. 10%, 20%, 11 September.
Same order, my lord. No coercive action, my lord. So in this case,
Item 46.
May it please your lordship, in item 46 and 49, the petitioner has challenged the order of the first appellate authority under the GST Act. But however, your lordship may be pleased to mention the assessment year because it's the same petitioner for two different assessment years. In item 46, it's for 2019-20 and 49, it's for 2017 and 18.
10% and 20%.
10% has
10% has been deposited because it is
Your lordship,
not controlled.
for delay it has been rejected.
So at the time of filing, you have
deposited 10%. Yes.
For filing, there is a requirement.
All right. 10%, 20%. Make it 18 September.
Item 47.
Your lordship, 47 and 48 similar order may be passed, but it's for two different assessment years. 47, 2018 and 19 and 48, 2017.
Anyway, for
your lordship,
notice, we don't need
in
to
the IA.
notice all that, those facts. Simply same order. Right.
Item 49.
49 is for the different assessment year.
Correct.
2017.
Same, all.
Same.
10%, 20%, 18 September, all this.
And 50 also.
50 we sent.
49, 50. Everything same. 51 is over already.
Item 52.
Highly obliged.
No, please.
Item number 53.
No, please.
Item number 54.
No, please.
Item.
May I please, your lordship? My item 55, your lordship. May I please, my lord?
Yes, please.
Though there is a defect, I have a limited grievance for your lordship's kind consideration. A writ petition has been filed in prayer number 5. Prayer has been made to regularize the service of the petitioner, the present respondent. Now, by virtue of interim order passed in the case, the service has been regularized, that is at page 74 and 75. My limited grievance is, if your lordship pleases, it may be clarified that despite this regularization, the writ may be considered on merit. Because, my lord, the interim order was passed directing that unless it is complied with, he will be, my lord, a contempt action will be taken, and that is how it has been complied with. Your lordship will produce the order. So, therefore, my lord, what has happened, the relief which could have been granted finally in the writ petition has been granted in the shape of a interim.
But it will be subject to the outcome of the writ petition.
But that much I beg, my lord, that the writ petition may be decided on merit, not on the basis of, because of the fact that the interim order it has.
All right. I please you. There is a delay of 11 months. So
But that is
just condemned. And 11 months has not been condoned. Therefore, the stamp reporter has pointed out it could not be because the delay, because it's not been complied with, defects have not been complied with. So the writ appeal copy has also not been served on me. And the order which was passed, that has been complied with. You also see that order.
Correct. So it will be subject to the outcome.
That is always our
It is not in dispute that the impugned interim order dated 20th June 2019 of the learned single judge in writ petition civil 5945 2011 has been complied with by the present appellant. Full stop. However, Mr. S.K. Mishra and counsel for the appellant points out that compliance was at the pain of contempt, as is evident from the impugned interim order. Full stop. Mr. Buddhadev Rautril and the senior counsel appearing for the respondent also confirms that the impugned interim order has been implemented. Full stop. Lest it should be construed that at an interim stage, the final relief itself was granted. The court would like to clarify that the implementation of the impugned interim order will not be taken to mean that no issue survives for decision in the writ petition. Full stop. The compliance with the impugn interim order would obviously be subject to the final outcome of the writ petition. Full stop. Secondly, it is clarified that the writ petition will be decided independently on merits, uninfluenced by the impugn interim order.
I'm deeply grateful, my lord.
Full stop. The writ appeal is disposed of, delay condoned.
I'm deeply grateful, my lord.
All right. That goes back to the single judge. The writ petition goes back to the single judge.
My lord, my lord.
And to be listed with the roster bench for directions on 1st May.
Grateful.
Item not 56.
None appears for the appellant dismissed.
56 I am for the respondents.
Right.
Item not 57.
I wouldn't. Those good them.
None appears dismissed.
Item not 58.
My lords, they are covered matter, my lords. That closing stock valuation.
Yes, my lord. The other question is there, my lord. That four question is there, my lord. I am supported by two judgment of Supreme Court. Lordship,
There also he has lost. 60.
No.
The
So far as provision of royalties 43B, not Supreme Court in two cases not held that actual payment has to be considered. In the so far as the my lord ESI and payment, and second one is the my lord. I'll request lordship kindly take it to next week, lords. Okay, lord, just I have received the next.
They are appeal, my lords.
Therefore,
They have lost.
Same assessing.
No, same as not lost, my lord. One issue is what my senior is saying. That is correct, my lord. I am not. But there is not only one question. There are other question is there. Therefore, I am saying, lord, next week, lordship keep it.
Page 32, my lords, may kindly see. We found that the findings of the learned AO on valuation of closing stock as referred in the assessment order cannot be overruled. And whereas the calculation adopted by the assessee is one of the.
No, but he's issuing, he's raising an issue and provision for royalty.
Yes,
that is what
that also I am taking, my lords.
There are two judgment, my lord. Recently, my lord, the
43 capital B.
Yes, that is where Checkmate Service Private Limited. They are on the your lordship has earlier disposed in basing on the earlier judgment. They are where they paid, but not in the due time. There was Supreme Court says the actual payment has to be made in the same assessment year.
That is after the amendment. This after the amendment, which was brought with the effect. We have not seen the amendment.
I have seen. I have explained. Therefore, I'm explaining next week, your lordship. Therefore, I'm requesting that. Therefore, I am
very good, very good.
All right. On the question of valuation of closing stock, the order dated, the issue stands decided against the department by the order dated 21st February 2022.
Yes.
Passed with this court in ITA number 5 of 2014, bracket Commissioner of Income Tax versus Odisha Mining Corporation, which was for assessment year 2009-10, whereas the present appeal pertains to AY 10-11 paragraph. Mr. Satpathy Leonard, Senior Standing Counsel of the Department, nevertheless wants to address argument on another issue raised concerning provision for royalty.
Yes.
Relatable to section 43 capital B bracket small a of the Income Tax Act 1961. Full stop. On this, limited to this aspect, at his request, list on
March. March. March.
17th May.
17th May.
All right.
Much obliged.
All right.
Item number 59.
Letter. Sambalpur district. My lord, item 57, my lord.
59.
59, it is regarding that elephant corridor. And we are one of the party, your lordship directed chief secretary, and other matters, your lordship hearing. But here I am appearing for a TPNODL now. We have already auctioned and tendered, and already we are doing all elephant corridors.
All right.
We have done.
You see, the issue raised in the present letter petition regarding deaths of elephants is already being considered by this court in another bunch of PILs. That is WP 614 of 2022, which is not available. 13th March 2023. Accordingly, the court would not like to multiply petitions on the same issue. The present petition is disposed of.
Item number 60.
My lord, item number 60.
Pardon, my lord, I am on VC, my lord.
Your lordship may kindly see the letter I have submitted. That charge sheet has been submitted. All the delinquent OS officers, sanction has been given by the government, and CS number dated I have submitted.
All right.
This is letter number 60 dated 10th January 2023.
Right. You see, Mr. D.K. Mantri, learned AGA, has placed before the court copy of a communication dated 10th January 2023, received from the Deputy Superintendent of Police Vigilance, Sambalpur Division, Sambalpur, informing that sanction orders have been received in respect of all the government officials in question, and a charge sheet has been submitted on 29th October 2022 under section 13(2) read with 13(1)(d) of the Prevention of Corruption Act 1988 and other sections of the IPC. Stop. In that view, the matter, no further directions are called for as far as the present petition is concerned. The court expresses the hope that the department will now proceed in accordance with law as expeditiously as possible and take matters to the logical conclusion. The petition is disposed.
Item number 61.
61. That additional affidavit, what I find the instructions are in my file, but I have to file it in shape of affidavit. Your lordship may give me any shortest adjournment. Without fail, your lordship may not impose any cost conditional order, shortest date maybe 10 days. 10, because the collector is to give, the Cuttack collector, I will immediately ask him to come and file the affidavit.
Faced with the reality that despite a last opportunity having been granted, no supplementary affidavit has been filed. Mr. D.K. Mantri, actually government advocate, now assures the court that such affidavit will positively be filed
within 7 days.
On or before 17th February.
17th February.
2023. Sorry. Stop. List on 22nd February. 22nd, sir.
Yes, my lord. We will file it by 7th.
Item number 62.
My lord, your complaints to your lordship's order dated 19/4/21. Just now they have given the complaint.
We have filed the complaints.
Lordship may call it 6 weeks after we can verify and see that, because can't be able to go through it.
A compliance affidavit has been handed over in court today by Mr. D.K. Mantri, a copy of which has been handed over to Mr. D.K. Mantri and senior counsel for the petitioners, who needs time to seek instructions. Stop. List on 11th May.
Item number 63.
Please, my lord. Well, before I start, my lord, I'm very thankful to my lords that I got an opportunity to appear through virtual.
Oh, yes. Thank you. It's good. From our virtual court. All right.
We should welcome.
Person I am appearing, my lord, I'm seeking my lord's permission.
Okay.
Last time also physically I appeared before my lord's.
Right.
My lord, in this matter, my lord, on 7th September 21, my lord.
Yes.
Lord, directed the DLSA, both Kalahandi and Navarampur, my lord.
Right.
To submit a report after visiting various hospitals in the two districts.
Correct.
Both the DLSA submitted their report, my lord.
Right.
And as per their report, my lord, various issues has been raised, my lord.
Right.
Including, if I will see Kalahandi first, my lord.
Right.
And in Kalahandi, my lord, if my lord give me a permission, then I will read 1-2 pages, my lord.
Yes.
This is a report, my lord. I think this is, as for me, it is page 70, I think, 71, my lord.
Right.
It is in the affidavit, additional affidavit filed by the Government of Odisha, my lord, 27/7/21, my lord. That is there. My lord, got it. Please, my lord. This is 1st October 21. Report submitted on 1st October 21, my lord.
Right. 27/7. Correct.
Please, my lord.
Ah.
So I'm going through the report, my lord. I read it, my lord.
No, the report of the DLSA.
The report of the DLSA, my lord.
Ah, sir. All right. Yes.
This is a report, my lord. I'm reading the first line, my lord. In view of the direction issued by the Honorable High Court of Orissa at Cuttack by the order dated 7 September 21 in the matter of so and so, DLSA appointed a 5-member committee.
Yes.
My lord, the 5 members were appointed. After that, my lord, in compliance of the direction issued by the Honorable High Court at Cuttack, Secretary DLSA Kalahandi provided all necessary documents, including order dated 7 September and 15th September in WPC number so and so. This committee, in order to comply the direction, started its ground visit on 23rd September 21. Started from District Headquarters Hospital Bhawanipatna. Before proceed to the hospital campus, this committee met Chief District Medical Officer CDMO Kalahandi at his office in order to know the conditions of the hospital in district, the availability of COVID testing kits in Kalahandi district, and to verify the documents submitted by the state of Odisha before the Honorable High Court, before the Honorable Orissa High Court. He issued to provide status of the all hospital, both CHC and PSC, within a day or two, agreed with the request of the CDMO, and in order to grant him some time, we proceeded towards District Headquarters Hospital, Bhawanipatna campus. It was on 24 September 21, the CDMO Kalahandi handed over a copy of the available bed vacancies at various levels, COVID sample collections, number, etc. at various hospitals at Kalahandi district, including District Headquarters Hospital. We visited almost all CHC all over the district and visited some of the PSC and sub-centers. However, it was not possible on our part in a short span of time to visit all the PSC and sub-centers in the district. We are thankful to our Secretary DLSA for granting us further time to complete our report in order to comply the direction of Honorable High Court of Orissa. On our visit to some of the sub-centers in villages, we came to know that almost all the sub-centers are not functional. During our visit, we also found that a maximum of buildings of CHC and PSC are in a dilapidated status state of or having water leakages constructed more than 40 years back. Also, we are informed that the staff quarters are not sufficient for the existing staff, or which the staffs are not available around the clock at the hospital premises for the emergency requirements. On discussion with the medical officers of various CHC all over the district, we came to know that buffer analyzer and required chemicals are not available, not supplied by the administration. As such, the patholab tests like serum, sodium, potassium, LFT, lipid profile, and thyroid tests are not being conducted at the CHC. Accordingly, the patients are bound to move towards private hospital path lab outside in order to avail the facility by paying the cost from their own pocket. The details of vacancy of doctors position in Golandi district is attached at Annex 1. Now, my lord, have a look to the vacancy position, my lord.
No, what's today's position? This was September 21.
Today also, my lord, vacancy now increasing, my lord.
Let me, file, my lord, affidavit. Currently, whatever the situations are, because
let it be better, sir.
My lord, I'll file.
Not merely filing an affidavit, because you will take time. The time from today till when you are file, the situation must be better, not worse.
Yes, my lord. We will ensure that, my lord, the situation to be better, my lord.
And not only this, in each of those other SDH, Dharamgarh, Udit Narayanpur, Kesinga, all of these places.
Even in a district hospital, Bhavani Patna also.
It shouldn't be that only in the headquarters hospital somehow things are okay, and outlying stations, it's all. See, the general complaint one sees is that rural Orissa, the health service, public health services are non-existent. I mean, that's the general feedback one gets. And that situation has to change.
My lord, we
are driving people to private medical care, which is unaffordable, expensive.
And similar situation is in Navarampur also, my lord.
That's right. That's right. See, the reports submitted by the district legal services authorities, both at Kalahandi, Bhavani Patna, and Nabarangpur, depict a dismal picture of the state of public health services in both districts. While the dire situation that existed during the COVID-19 pandemic may now not be found, the fact remains that the basic problems for a robust public health infrastructure are found unaddressed. Most of these include availability of sufficient medical personnel, nurses and staff, not only at the district headquarters hospitals in both districts, but also at the community health centers, bracket CHCs, and the primary health centers, bracket PHCs. In the taluks, public tehsils, and blocks in both districts. Further, facilities like X-ray, ECG, ultrasound are shown not to be available. Full stop. The bed capacities are inadequate. The buildings are themselves in dilapidated conditions. Full stop. In many places, a single doctor was running the entire CHC, and patients were forced to seek private medical care at unaffordable personal expense. Full stop. The reports are fairly detailed as the teams have visited almost every PHC, almost every CHC, and a sampling of PHCs. Full stop. Another aspect that gives cause for concern is the lack of proper training to the ASHA workers, ASHA workers, and paramedical staff. Full stop. The court would like to reiterate that the concerns expressed by the petitioners are not limited to the situation that prevailed during the COVID-19 pandemic, but about the general status of the public health system in the districts. Full stop. And yet, Kalahandi and Navrangpur are just two of the districts, but maybe symptomatic of the general condition of the public health system in the districts in Odisha. Paragraph. Mr. Joshi, who appears in virtual mode and has taken the court through the reports, urges that directions be issued to the state to put in place a plan of action to address each of the shortcomings pointed out in the reports of the two DLSs. Paragraph. Mr. Tripathi Leonard, standing counsel for the additional government advocate for appearing for the state, undertakes that detailed affidavits will be filed addressing each of the shortcomings pointed out in the report of the two DLSAs to present the court with an updated status on each of the above aspects, including the availability, the filling up of all the vacant posts of doctors, nurses, and staff, the stocking of medicines, the repairs to the buildings and infrastructure, the availability of the facilities of ECG, ultrasound, testing facilities, as well as training provided to ASHA and paramedical staff. Mr. Tripathi, I've been reading how the ASHA workers have been agitating for a very long time about the inadequacy of payment. I don't know what you're doing for addressing that.
Lord, there was a meeting which had taken place wherein that leprosy committee meeting, we had discussed about all those issues, my lord. State level monitoring committee.
We keep discussing endlessly. What is the action on the ground?
Some steps are being taken now.
That's as vague as possible. How much, Mr. Joshi, are you aware how much does an ASHA worker get paid per month? Are you aware?
They get a kind of an incentive, my lord.
It is a very low amount as per their schedule of work.
What is it? Is it at least minimum wages?
I can inform.
If you calculate minimum wages, is it?
Yes.
Is it commensurate with at least minimum wages?
Minimum wages.
My lord, since this is a project of the National Health Mission of the central government,
whether national, state, whatever, why should they work less than minimum wages?
Even today they are sitting in strike.
And this is not even a non-skilled work. ASHA is a skilled work. out how, because he's administrative judge for Malkangiri. He says the medical, in the jail there, it's the pharmacist who's available, not the doctor. And in many such places, only a pharmacist is there, no doctor is available.
I'm agree, my lord. I'm also visited various hospitals, my lord. Same situation. Pharmacists are there, but there is no doctors. Even machineries are also not in a good condition.
We'll do one thing on the next hearing. Let both the CDMOs be present in virtual mode.
Yes, sir.
You see both the affidavits in respect of both districts by the prepared and filed by the respective chief district medical officers will positively be filed on or before 1st May 2023. A list on 16th May. 16th May 2023 at 2 p.m.
2 p.m.
Both the CDMOs of
Nabarangpur.
Kalandi and Nabarangpur shall remain present in virtual mode on the next date. Full stop. All right, Mr. Joshi, thank you.
Item number 64.
From 64, I am appearing for the contesting opposite party. Last week, I have entered my appearance. I have called my client for filing counter.
No, 1 minute. Who's for the petitioner?
If I may please, Your Lordship, I am for the petitioner. Lordship, this matter relates to encroachment on 3 roads, Your Lordship.
All right. Anyway, he's accept noted. You say counsel appearing for opposite party?
4 million.
4 assures the court that contract will be filed within
10 days.
Within 10 days. What you were to inform Mr. Monty?
Yes, my lord. I have to inform the
action taken to implement order of the sub-collector.
that time. Next day I will give.
Mr. Monty also seeks time to inform the court of the action taken to implement the order passed by the sub-collector in appeal. Full stop. Who has to give you that instruction?
Sub-collector.
All right. On the next date, the sub-collector. What, Jagat Singhpur?
Yes, ma'am. I'll positively file.
No. Also let him be present. Be present in virtual.
My lord, sub-collector is also not a party to this.
That's all.
Tahsildar can be.
Or in the Tahsildar Balikuda will remain present in virtual mode. You see, the affidavits we filed positively on or before 1st March 2023.
First March.
14th March. List on 14th.
I'll be filing my detailed counter, but one fact I must bring to your lordship's notice, my lord. In respect of the same plot, a civil suit is pending and in restraint order is there for declaration of right title interest.
This is the whole problem, sir. Some Gochar land, you will take a restraint order and that's it. Endlessly carry on. All right.
Much obliged.
Item number 65.
65 and my lord 66 stands covered by your lordship's judgment that Cobra International extends. It has not been a post facto extension. And
your lordship may kindly turn to order dated 17th November 2022.
Just a minute, my case.
My lord has asked.
Yeah, I asked him, sir.
My lord has asked.
Sorry.
Larger bench of the Supreme Court.
Yes.
Your lordship.
So it will have to await, sir, anyway.
Await, my lords. Yes, there has been no stay, my lords. That lordship may please be grant stay, my lords, till the judgment of
One thing, your lordship may kindly turn to para 3. Another ground on the last occasion, my lord and senior has asked another ground that 41-4, 7 days issue, your lordship. Pie on the face of the record, and so far as the instruction is concerned, your lordship, that 7 days issue does not come into play. Your lordship, that instruction, that within 7 days that notice has been issued, and
Okay,
also I have enclosed that order
Okay,
sheet.
I'm not pressing that issue.
Your-
All right.
Your
will-
lordship, madam, last occasion, my lord and senior has not placed the first issue, and then placed the second issue with this.
No, I am
with an amendment that I not wait for that.
You have to file an affidavit. What happened?
Your lordship, I'm sorry, just
Yes,
instruction I have
yes,
received.
I
I have received the instruction, your lordship, I have perused the instruction, your lordship. And also I have enclosed the order sheet.
No, you file an affidavit.
Also I have
File
enclosed
an
the order sheet.
affidavit and also, my lords,
Mr. Mishra states that he will positively file the affidavit in terms of the previous order within 4 weeks with an advance copy to the counsel for the petitioner.
And
Affidavit
records may
states
be
that the
produced, my
judgment of the Supreme Court.
So far as the second issue also, your lordship has adjourned sine die, because that issue is also pending for
As
the
regards
Supreme
the
Court.
correctness of its earlier decision in State of Punjab versus Shreyans Industries Limited, 2016-4 ACC 769 is still awaited. Is still awaited. Correct. This can now go to.
Your lordship, in the second issue also,
My lords,
your
Can
lordship
go to
was-
18th September.
18th September, there is a.
it is in the second issue. So far as the 41-4 is also before the Supreme
It's
Court.
all right. It's
Your
all right.
lordship,
All right.
gratefully.
Item 66.
My lords, interim order.
There is no interim order in this.
My lord, interim order is not there.
So you don't need some. From 2014, you never had interim
My
order.
lords, they are pressing hard, my lords. At least lordship may be
No.
kind enough.
Just speak to Mr. Mishra and he will.
I think it is nine. Interim order ଅଛି ବୋଧେ? Interim order is there, my lords.
No, I didn't find any.
Just 1 second, my lords. Let me check up. One, it may, lordship may. Yes.
Interim orders to continue. All right. Interim orders to continue. All right.
And
I think he was.
in any case, my lord and senior won't stand means he will obtain the interim order, and he has obtained already interim order.
All right.
66.
66 same, my lords.
Same.
One is under the bat.
65, 66.
Other is under the.
Yes.
Item 67.
May I please, let's see, in this, in the last occasion, my learned friend was.
Your lordship, item number 67, your lordship had order dated 1st November 2022, your lordship has admitted this matter.
Already.
Directed to file counter, your lordship.
No,
Your
only to
lordship,
take
I need
instruction.
4 weeks more time.
Your lordship,
to file the
already it is
counter. Your
covered.
lordship, also extra copy has not been served on.
Already it is covered by, your lordships kindly have a glance at the order I have placed. Where Sanjay Fabrics has been taken into account in the Hirakud case, your lordship, page 7. In the Hirakud Power Company case, page 7, your lordship.
Correct.
Your lordship, just one occasion, last chance.
Last opportunity.
Yeah,
for the department to file reply within 4 weeks. Rejoined.
Only it is covered, your lordship. If my learned friend takes instruction, then it will be disposed of. This is matter of 2016, your lordship. Third round litigation.
I'm sorry, your lordship, I'm sorry, I have not taken.
Only if it is covered.
27th March. 27.
Your lordship, grateful, your lordship.
Item number 68.
16 Lord, I request Lord for his time to file counter. Lordship was earlier directed to file counter, but I could not.
All right. Reply within 4 weeks. Yes. Interim orders to continue. List on 11th September.
Item number 69.
But item 69 to 72 all are TCS matters, covered matter. I have given Lord 4 matters I have corrected.
My lord, 73 and 74 also similar.
Sorry?
73 and 74 is also similar.
All right. So 73, 74 also. But you'll have to give corrected orders. You have those.
I have given.
Oh, for 73, 74 also.
No. He is to give.
You better give. Not today. Now.
My lord, I am appearing for the opposite party corporation.
So I'll give it corrected, my lord. During the lunch hour, I will.
All right.
My lord, I am appearing for the opposite party corporation.
All right. 75 now.
Item 75.
75, I'm filing rejoinder today. But I have already served the copy to the other side. But with regard to service of notice to OP number 5, it has The AD has returned without his signature.
That's all right.
If lordships say, then
Since
I'll
the AD
clear.
card has been received from opposite party number 5.
But nobody is appearing.
Fresh step. Because he has not signed the AD. So he has
But
to
without
take-
a signature, fresh notice returnable. August 17th.
There is an order of this own court on 24 February directing the State Council to file additional affidavit. But till date, they have not filed. Though,
Additional affidavit
with
will
regard
not be
to
filed by
issue
that.
in this matter, this court has directed specifying. Here they have, my area has been deducted and has been granted to another sub.
I see.
That is the only point.
All right.
75 ready.
Yes, it's 24 February. 24th February 2020. That is a noting also, additional affidavit has not been filed by the state.
Right.
Item 76.
Lord, this is for the year 19. The Lordship will find a peculiar fact here. The petitioner here is the OSF licensee. The shop, in fact, was completely demolished and destroyed close by Noxals in the Noxalate area. And these are all facts, those admitted, man. Collector himself says that shop cannot be renewed. Shop cannot be opened because the law and order situation, Noxalites have prohibited opening of shops, liquor shops. They have imposed a ban. Collector himself reports this matter, my lord. Collector reports to the commissioner. Now, commissioner also has reported the matter to the government on the question of waiver of license fee and MGQ. Man. That's the issue, man. Now the demand is there by the collector or superintendent. But then the collector himself has recommended waiver that your lordship will find page 39. Man. I'll just show your lordship those two letters, one by the commissioner and other by the collector. Kindly similar.
So what do they say in the counter now?
Beg pardon.
What do
They are all admitted. Those aspects are admitted.
No, annexure B/4. He has given an undertaking in shape of affidavit that.
No, that was the beginning, sir. That affidavit he has to give, otherwise he won't give him that. It's all conditional. He didn't anticipate that there will be this problem.
Then he may challenge this collector's demand in appeal and place all these facts.
Commissioner has already recommended. Government has
No, commissioner has not recommended.
Yes, and this is the commissioner's recommendation, Mr. Mahan. That is there, page 40, 43 onwards, page 42 onwards. Kindly see. 42 onwards. Commissioner,
42 is your appeal.
Lord, 42. Lord, I'm sorry, Lord. I beg excuse. I am in fact placing the second matter. I'm so sorry. Lord. I beg excuse, man. The second matter. Kindly take up the second one.
Second.
Yes.
763.
I forgot to mention, my lord. I'm sorry. At the beginning, I should have said that. 42. Right, page 40.
Yes.
Kindly similar, the commissioner writes to the government with reference to correspondence survey. I am to say, in this connection, Collector Koraput has furnished factual report stated that Lakhimpur OS shop, its 4 branch shops were settled during 8-9 in favor of BP holders. So the said shop was also renewed 9-10, functioning smoothly. But 9-6-2009, Chasi Mulia Adivasi Sangha and Naxalites have attacked the OS shop at Lakhimpur, destroyed the OS shop liquor, Mohaflower, fermented Mohavas, other distillery apparatus sites, and also made anti-liquor campaign in that area, which caused law and order situation. The situation was reviewed by the then collector by letter number 99/2009, addressed to the excise directorate, as well as the government intimated that anti-liquor agitation of Chasimuli Adivasi Sangha, Badhugaon and Nayar Patana area has entered Lakhimpur also, and result of OS shop, as a result, the OS shop at Narayan Patana, Badhugaon, Lakhimpur, and IFL off shop at Lakhimpur have remained closed from 4/1/09, 7/2/09, 9/6/09, and 26/8/09 respectively. The collector has also suggested not to open new liquor shops in the aforesaid block area. So the Lakhimpur OS shop could not be opened remaining period 19. Then your lordship may straightway see page 44. In fact and circumstances, the demand notice raised relating to closure period may not be sustainable and government may consider to exempt the same. But it's got it, man.
Yes. In fact, the demand, clearly they say the demand is unsustainable.
No, but thereafter, the state government has taken a decision. Your lordship may see annexure 22, that is a subsequent letter of 2012, in which
For the same period.
that the recommendation has been made to realize the unrealized amount from the. So despite such recommendation, if the government is taking this stand, then he cannot rely upon that
No,
recommendation.
then it means it's unreasonable.
No, that is.
See, ultimately, you are going to send him again back before the same commissioner, same hierarchy.
No, I don't say that commissioner, he should go to because commissioner has recommended, government has apparently declined to entertain such recommendation. I can file a counter to this.
Government has only wanted a clarification, not decline. Page 54, kindly see, Manu.
Because this
Facts
is
are
all are
Kindly
disputed
see page
facts.
54.
Let me get clarity in the matter and file a counter affidavit by the government itself. And
Mr. P.K. Rathore, learned counsel,
demand may not be enforced now.
put both matters together. Points
Yes,
out
both
how the excise commissioner had himself opined in a letter addressed on 24th. Sorry.
Twelfth of October 2011.
In a letter dated 12th October 2011, addressed to the Additional Secretary to the Government Excise Department, that the demand raised for the period during which the OS shop was closed due to the attack of the Chasi Mulia Adivasi Sangha and the Naxalites, and due to the law and order problem in the area, may not be sustainable, and that the government should consider exempting the same, open quotation, exempting the same, unquote. Mr. D.K. Manthi, learned additional government advocate, states that he will seek instructions and a parawise reply will be filed with both petitions positively within 4 weeks. Rejoin to that if any be filed the next day. Interim orders to continue. List on
Sometime April, my lord. Sometime April, my lord. Sometime April, my lord.
27th April.
Grateful.
All right.
Interim orders to continue.
I've said that.
Item number 77.
May I please, Your Lordship? Your Lordship, in this case, there is a change in counsel, Your Lordship. I am filing the fresh wakalatnama along with the appearance memo of Senior Advocate Mr. S.K. Paddy, my Lords. Along with that, Your Lordship, I am also filing the subsequent development in the matter in way of additional affidavit, which may be kept on record, my Lords. I'll serve copies right now, my Lords, in the court.
The name of so-and-so be indicated for the appellate.
I may be pardoned.
Yes.
An additional affidavit has been handed over on behalf of the applicant, bringing and record the subsequent developments. Copy thereof has been served on counsel for the opposite parties of the respondents. Who's that? Respondent state. No, that's what about the other?
The main party is actually Hotel Association of
Correct.
The other
I may be pardoned, my Lords.
Respond number one.
I'm appearing on behalf of Mr. Debashish Panda. We have instructions to appear in this matter for the opposite party, my Lords. Hotel Association, my Lords.
All right. You say Mr. Devashish Panda enters appearance for respondent number 1. Copy of the additional affidavit be served on him today itself.
We'll file wakalatnama within 2 weeks' time, my Lords.
Whatever you file on. List on 18 September.
Grateful, my Lords.
Okay.
Item number 78.
On 25/8/2022, Your Lordship directed the government to file the affidavit. They were supposed to file. Today, actually, just now I received the copy of the affidavit.
All right. Rejoinder be filed for the next date. List on 18 September. Right.
Item 79.
Item 79, this is a dispute between the staff of an aided high school, my lord. And it's a final hearing matter. It will take some time. Your lordship permit, right?
All right. List on 25th September.
Item number 80.
Your lordship posted
25th September. Item number 80.
80 minutes, I'm there, my lords. Your lordship sees the last order, my lords. Your lordship had directed me to take fresh notice upon respondent number 8. I had filed the requisites. Sees the contesting respondent.
What happened? Served or not served? AD not resolved, received.
My lords.
Tracking report?
Tracking report, my lords, your lordship had directed to place.
Where's the tracking report? Neither has the AD card been received back from respond by 8 nor a tracking report placed in record. Oh, it is back. Valid service. Okay. All right. None appears for respond by 8 despite valid service. Now what?
Let's say prepared a brief date chart, my lord, for your lordship's convenience.
Gram Sikya. Now that post itself is not there.
Well, that post is not there, my lords. But my lords, I am entitled to the present post, that is Ganasikyako, my lords. Had I been, my lords, because I was successful, my lord, during the 2 rounds of earlier litigation, my lords, that my lords, when I approached this honorable court, your lordships may kindly see my notes, my lords. I given those orders also. Now, my lords, wide annexure 1, my lords, to my writ appeal, my lords. Pursuant to the resolution of the Village Education Committee, my lords, there are 5 applicants, my lord, for the post of education volunteer. Now, my lords, I was one amongst them, and the present respondent number 8, my lords, had not even applied for the same. And the Village Education Committee, my lords, they had recommended my name along with 2 other applicants. But, my lords, thereafter, my lords, all of a sudden, my lords, they appointed respondent number 8. Now, my lords, challenging that, I approached this honorable court, my lords, 5 WPC number, my lords, that your lordships may kindly see I have given that order, my lords, to my written note at page 6. At page 6 of my written note, my lords, I have given, that is WPC number 7368 of 2003. This honorable court, my lords, directed the collector Balasore to make an inquiry on my representation by giving opportunity of hearing to both the parties. And my lords, then to thereafter, my lords, your lordships may kindly see annexure 2, the inquiry report. This is very important, my lords. I'll just place the relevant portion at page 16.
Yes.
The inquiry report, my lords, if your lordship sees the last portion, while I was going through the documents, this is the report, while I was going through the documents available in the file, I saw that the VEC in its 3rd sitting dated 29/2002 has resolved that they have received 5 applications for the post of EV for Biripoda EGS Center. Out of these 5 candidates, the committee made panel of 3 names for candidates. They are Bankim Sen, Phulamani Behra and Dombardhar Behra, who is the present appellant. The committee was silent about Sudhanshu Shekhar Mishra and Duryodhana Sethi. These are the other 2 applicants. So the district project officer Baleswar in his order dated 10/10/2002 objected the proposal with a remark to submit all the certificates of Sri Mishra and Sri Sethi. Thereafter, my lords, instead of submitting the documents pertaining to Sri Mishra and Sri Sethi, the VEC submitted its resolution number 5 dated 2/12/2002, wherein they had proposed the names of Srimati Sandhya Rani Mandal, who is the respondent number 8, my lords, and Satyaranjan Sen, Surendra Sahu. In this second proposal, none from the first list was enlisted. Therefore, it is undoubtedly clear that committee had taken a biased view. Without submitting the documents of Sudhanshu Shekhar Mishra and Durjadana Sethi, they have submitted a second panel of names by overtaking the case of Dambardhar Behera, whose claim seems to be justified. Therefore, I am of the view that the second proposal for selection of EV may not be accepted. The DPO may be directed to call for the data pertaining to educational qualifications of all the 5 candidates and select the best among 5. While doing so, while duly, so he may also invite all the members of the VEC to the selection meeting. Now, my lords, while Annexure 3, my lords, this report of the ADM was concurred by the collector, my lords, and he gave a seal of approval to that. Now, thereafter, my lords, still there was inaction on their part to implement this order of the collector, which was dated 31/5/2004. Now, my lords, I approach this honorable court again, my lords. That order, my lords, I have given at page 8 of my note. That is, my lords, WPC number 10319 of 2004. Right. If your lordships may permit me, I'll place that order. This is important, my lords. Page 10. The dispute in the present writ petition relates to selection and engagement of education volunteer in respect of Biripada EGS Center in the district of Balasore. The subject matter of this writ petition was earlier before this court in WPC so-and-so disposed of on 1/8/2003. In consonance with the direction issued in that writ petition, the collector got an inquiry conducted by the ADM, Balasore, who held as follows. Then that has been quoted. It is pertinent to mention here that OP number 4, whose name was found in the select list, having not assailed the aforesaid order, that orders remains binding on him. Mr. K.K. Swain, learned counsel for the petitioner, submits that though the aforesaid direction was given on 29/5/2004, no action is being taken thereon till date. After hearing learned counsel for the state, this court disposes of the writ petition with direction to the opposite party authorities to implement the direction quoted supra as expeditiously as possible, preferably within 3 months hence, if there will be no impediment. In spite of this, my lords, in spite of this order also, they did not implement. And thereafter, I filed a contempt in the year 2008. Now, that contempt also got disposed of in the year 2016, wherein this honorable court, my lords, observed that since that post has been done away with, and those retrenched education volunteers have been, my lords, appointed as Ganasikyoko, so I am not eligible. The contempt was dropped on that ground. So, my lords, my respectful submission is, my lords, the persons who were then appointed as EB, just like the respondent number 8, and that post I had also applied for, that, and the present post of Ganasikyoko is nothing but a continuation of that post. That is why Annexure 8.
So respondent 8 is also working as Ganasikyoko now.
Presently, she is working. Because initially she had applied, she did not apply at all. I had applied. And I was successful also. And your lordships have seen the orders of this honorable court also. Now, thereafter, my lords, after the disposal of the contempt petition, my lords, I filed a detailed representation for my appointment as Ganasikyoko, describing all the previous writ petitions and everything. That is at Annexure 6. And thereafter, I approached this honorable court by the writ petition, which is under challenge, my lords. And this honorable court, the honorable single judge, has held, my lords, that I'm not eligible to be appointed as a Ganasikyoko because I was earlier not holding the post of EV, as well as it has observed, my lord, as running page 32. One of the observations, my lords, it is a fact that Sandhya Rani Mandal has been in the middle portion. It is a fact that Sandhya Rani Mandal has been engaged to perform her regular duty as education volunteer after validly being selected by the village education committee. How can it be, my lords? My lords, this honorable court has also held in the 2004 writ petition that the ADM and the collector have come to a conclusion, my lords, that her appointment does not have the sanctity of law, and that was also, my lords, agreed upon by this honorable court. All right. And in the counter, my lords, they take a stand that I was not belonging to that area. So hence, my lords, my first submission to that is, my lords, they had not taken this stand before the writ court, before the honorable single judge, firstly. And second, my lords, so far as even taking that stand, my lords, my Ground is I have given annexed documents to my rejoinder. I belong to that area, my lords, to that Gram Panchayat, which is the requirement. And I rely upon certain decisions, my lords, which hold that, my lords, in service jurisprudence, my lords, long holding of a post, my lord, does not give you a lien over the post, my lords, if it is a case of wrong appointment. And my respectful submission, my lords, is the respondent number 8 was wrongly appointed to that post. Yes, sir.
My lord, may I kindly see the order of the Honorable Single Judge. That
This is the fourth round.
my lord.
Fourth round of litigation, sir.
Yes, my lord. My lord, previously, all the previous writ petitions were disposed of at the first date of the listing, that is without notice. But see, this writ petition which before your lordship, the impugned order, that has been based on the reply submitted, and is upon hearing both the parties, after going through all the materials available, this honorable court held that she was never been selected by the village education committee, and she was never been he was never been engaged as a education volunteer. So unless he is an education volunteer and unless he is a retrenched one, so that scheme for engagement of Ganashika will not.
Because you kept him busy in court. Meanwhile, you abolished the post, correct? Now you turn around and say, we never appointed you. He's not claiming that he was appointed. He's agreed that he's not appointed.
But that
he's been in our court since 2003 or 4.
The first writ petition is ballots of the year
2004.
No, 2003.
2003.
Immediately 20 years, you made him run around in circles. Picking up one complete list of people who never even applied. This
and moreover, my lord,
party number 8, she never even applied. And she's been now working as...
But the finding of the Honorable Single Judge is something different.
That's the point. That's why he's here before us. He's assailing that finding. In fact, your inquiry report shows that she could not have been regularly appointed.
No, inquiry report that has been reflected in the order of this Honorable Court in another writ petition which my learned friend has also placed. That does not show that the engagement were done, he was been ignored.
It is. In fact, the inquiry report precisely says that. Just come to the inquiry report now. It in fact says that. While I was going through the documents, come to the bottom of page 16. Just read that while I was going through the documents.
Madam. That is. While I was going through the documents available in the file.
This very report.
I saw the VEC in its third sitting dated 29/2002 has resolved that they have received 5 applications for the post of EB for Birpata Sachanchar. Out of these 5 candidates, the committee made panel of 3 candidates. They are Bankim Chandra Sen, Pulmani Behera, and Dambardhar Behera.
This is the man, Dambardhar.
Yes. Yes, my lord.
And this
the committee was silent about Sudhanshu Shekhar, Duryodhan Sethi, so he called for the certificate of these 2 because the committee is silent. Now they don't do this. They've picked up next page. It's all very extraordinary. They suddenly propose 3 names.
Right.
And this inquiry officer finds completely arbitrary.
Yes,
and then this was asked to be implemented by this court.
2007, page 10 and 11 of his notes.
Compilation.
Page 10, my lords.
11. Operative part. You were to implement. Have you challenged that?
No. The writ petition is allowed. You better now put him as Gram Sikyak only. What else? No? Gram Sikyak only. You'll have to give him a Gram Sikyak post.
Gana Sikyak.
Gana Sikyak. Sorry.
Ganasik is available, or that has also been nomenclatured with some other.
Some junior teacher.
Ganasik, no. Ganasik some Ganasik they are continuing after completion of 8 years. They have been regularized as primary school teachers.
6 years or 8 years?
No, Shiksha Sayak is a new another scheme.
Oh.
Ganasik is a different scheme. And for that, for purpose of Ganasik, there was a notification of the government with regard to that completion of the OTT, OSCT. So that is also under challenge before this.
Tell us, what will you take him as? This education?
No, education volunteer, that is not there. Ganasik.
It's there. Don't tomorrow say there's no Ganasik.
No,
we pass an order and then you come and tell us, because again, same contempt, everything will start.
Contempt will be.
Better I will
Instruction.
Getting the instruction, I will inform you.
All right, then we'll have to pass the short order. Okay, just give me that papers. You see the challenge in this writ appeal.
I'll keep it to Monday.
No, we'll give you an order, then you can take proper instructions, sir.
Yes.
We'll allow his prayer.
Yes.
The challenge in the present appeal is to an order dated 4th December 2007 passed by the single judge dismissing the appellant's writ petition civil 9662 of 2017. Thereby declining his prayer to be appointed as an education volunteer at the Baripada EGS Center, functioning under the School and Mass Education Department, (SME Department) of the Government of Orissa. Paragraph. This litigation has a checkered history. Full stop. It is extremely unfortunate that the appellant has had to return to this court 4 times to seek justice. Full stop. Paragraph. One of the qualifications for being appointed as education volunteer (EV) in the Education Guarantee Scheme (EGS) centers in the state of Orissa was that the applicant had to be a matriculate and belong to the same village/panchayat of the area. Full stop. The present appellant had completed his 10+2 in arts in 1998. Full stop. The Biripada EGS Center invited applications. The Village Education Committee (VEC) of the Biripada EGS Center invited applications for the post of EV. Full stop. Apart from the appellant, 4 others, namely Sudhanshu Shekhar Mishra, Duryodhan Sethi, Bankim Chandra Sen, and Fulamani Behra applied. Full stop. Of the 5 applicants, the VEC recommended 3 candidates, that is the present appellant, Bankim Chandra Sen, and Fulamani Behra, to the district project officer V.S. Baleshwar. Full stop. Interestingly, respondent number 8, Sandhya Rani,
Mandal,
had not even applied for the post and was as emerged in an inquiry conducted later under orders of this court. She was somehow appointed as EV on the recommendation of the DPO (EGS). Paragraph. When he was not selected, the petitioner first came to this court by filing the petition civil 7368 of 2003. Would stop the court by an order dated 1st August 2003, asked that his representation be considered by the collector and an inquiry and an order be passed. Full stop. Pursuant to the above order, the ADM Baleshwar conducted an inquiry and submitted a report dated 19th May 2004. To stop, the following portions of the report are telltale. 16, this 3rd paragraph from the bottom, while I was going through, up to 17 to the end paragraph. The above report therefore makes it explicit that the VEC had acted totally arbitrary in ignoring the claims of the present petitioner, present appellant, and in offering the post of EV, offering respondent by 8, who had not even applied for the post, the appointment as EV. Paragraph. When no action was taken on the above report, for the second time, the appellant had to file writ petition civil 10319 of 2004 in this court, which was disposed of by this court by the following order on 1/8/2007, A to A. Page 10 of this compilation. Unfortunate paragraph. Unfortunately, the above order was not complied with. So, the third visit by the appellant was to this court was by filing contempt case 688 of 2008. Full stop. The said contempt case was closed by an order dated 28 March 2016, recording the submission of the state that the EGS itself had been closed, and therefore the order could not be implemented. Paragraph. For the fourth time, the petitioner filed writ petition civil 9662 of 2017, in which the impugned order has been passed by this court by the learned single judge on 4th December 2017, rejecting the prayer of the appellant that he should now be engaged as Ganasekya, as was a relief similar to that granted to others identically placed as him. Paragraph. In the impugned order, the learned single judge has wrongly noted that open quotation, Sandhya Rani Mandal has been engaged to perform a regular duty as education volunteer after validly being selected by the village education committee, unquote. This is a factually erroneous observation in light of the inquiry report referred to herein before, which in no uncertain terms concludes that she had not even applied for the post and that there was no occasion for the VEC to even consider her candidacy. Full stop. There were only 5 applicants, and the present appellant had figured in the list, in the panel of 3 prepared by the VEC. Full stop. Paragraph. The above erroneous observation has led the learned single judge to decline relief to the present appellant. Full stop. The learned single judge has noted that respondent 8 had been, open quotation, taken as Ganasekya, unquote. Paragraph. Having heard the submissions of learned counsel to the appellant as well as Mahapatra learned standing counsel for the SME department, the court is of the view that a grave error was committed by the authorities in overlooking the appellant for the post of EV. And he has been made to run from pillar to post for the last 20 years for no fault of his. Full stop. The appointment of respondent by 8 as Ganasekya was clearly unsustainable in law, particularly since she never even applied for the post in the first place. We'll stop with the paragraph. One objection was taken in the counter affidavit filed in the present petition that the appellant is not a resident of the area. We'll stop. In the rejoinder filed, the appellant has placed copies of his educational certificates, and other documents, other relevant documents to show that he is in fact a resident of that very area, namely Biripada, Gram Panchayat.
My lords, Purushottampur Gram Panchayat. This Biripada comes under Purushottampur Gram
That is
Panchayat.
Purushottam Gram Panchayat, within which the Biripada,
Within the Biripada EGS center is located
within which that
Purus-
Biripada EGS center was located. Full stop. Paragraph. The court therefore sets aside the impugned order of the learned single judge and directs that the state should now disengage respondent number 8 as Ganasikik and engage the present appellate in her place. Full stop. Instead of requiring the appellant to keep coming back to the court for implementation of the orders of this court, the court requires the SME department to file a compliance report of the above direction within a period of 4 weeks from today. Full stop. List on. March 16th March.
I'm grateful. my lord.
I'm sorry, my lord, may I mention?
Yes, Mr. Badi.
My lord, item 54, we file a application to withdrawal. My sorry, my lord, Mr. Babita Sahu has passed over, my lordship has gone, the non-applied dismissed. If you we file an application for withdrawal, equally my lord can dispose of the same. We file the IA number 331/2003 because
all right. That IA is allowed, put down his appearance and disposed of his withdrawal. All right.
My lord, oblige, my lord.
Let's item number 81. Item number 81.
That's the next item.
Your Lordship. Your Lordship, there are these cases may be sine die. Your Lordship, in identical matter, Your Lordship, but that coal is the raw material or not, the SLP is pending before.
I have filed the appearance.
All right.
Name may kindly be.
The present petitions are adjourned sine die, awaiting the judgment of the Supreme Court in certain SLPs involving the same issues. Liberty is granted to the parties to mention these petitions for listing after the decision of the Supreme Court. All right.
I may pardon, my lord, item number 57. My lord, I was there in the court, but could not attend the...
Tell us. Yes, tell us, please.
My lord, there is a noting, my lord, the LCR of the writ petition has not been digitalized. Has been sent for digitalization. And since the writ petition is challenging the order of the member board of revenue, my lord, the LCR is required. Both,
all right,
my lord.
The LCR the digitized form LCR be placed on record before the next date. Be included before the next date. Interim order to continue.
Obliged, my lord.
List on. September 4th.
Obliged, my lord.
Password. Supplementary list pastor matter item number 11.
I am permitted to withdraw this writ application with the liberty to file a better application.
All right. Disposed of is withdrawn with liberty to file a better petition. All right.
Item number 27.
But the basing on the illegal encroachment of his own property by the OP number 567, Lord, the petitioner made a report before the sub-collector, and sub-collector, after hearing his grievance, Lord, instructed the Tahsildar to make an inquiry. Then Tahsildar made an inquiry, directed the RI to make an inquiry. And after inquiry, demarcations are made. Demarcations went in his favor, Lord. Thereafter, the Tahsildar and Annexure 8, Lord. After Annexure 8, Lord, directed for the eviction, Lord. Directed the ओडिया निश्चय पेज 20 मिलर एत द्वारा आपण मानक जणाई जाउछि कि डिमार्केशन अमीन रिपोर्ट को जणागला कि श्री मायाधर बेहरा प्रदीप कुमार बेहरा इता कौनकर बेहरा दैतारी बेहरा बनमाली सियाल कान सोन अधिक 8 डेसिमल विश्वनाथ नायक पिता अर्कुसारु अक्तेर करेछंती एनु यस
1 minute sir, notice the accepts notice for opposite parties 1 to
opposite parties 5 6 7 they
1 minute sir,
1 to
he is appearing.
sorry
1 to 3
1 to
4.
1 to 4 notice will now issue to 5 6 and 7 returnable on the next date.
Yes,
replies we filed within 4 weeks of service of notice. The tracking report we placed on record. List on 5th September.
Yes.
5th September.
Item number 34.
Let 5th September. 5th September.
Item 34.
My lord, this matter listed for orders for removal of defects, my lord. Let it come next week on any day, my lord.
The 4 petitioners have filed it and the prayer is on behalf of 141.
141.
How is that possible?
My lord, the petitioners are displaced and affected persons due to coal mines, my lord. So far as resettlement and rehabilitation.
Have you followed the question I asked you? Did you listen to the question I asked you?
My lord, the petitioners represent 141 affected and displaced persons who have lost their lands due to coal mines project.
Where are the names of 141 persons?
Therefore, my lord, I pray for adjournment. Some instructions are necessary, my lord.
Not like this. Either you file a proper petition then. Have you made a representation?
My lord,
have you made representation to
I have made representation. Representation pending.
Where is that?
That is under annexure 36. 36 at annexure 6, my lord. Before the collector and district magistrate Sundargarh.
Where is that? Proof of delivery of this representation. By something on the second page. I don't know who's received it. Is even if the chief minister, member, everything one omnibus representation. You better make a proper representation, sir, and have it signed by the 141 people.
Yes, my lord.
Council petitioner seeks leave to withdraw the present petition with liberty to first make a proper representation to the collector, and after following up on such representation to seek appropriate remedies in accordance with law. Disposed of is withdrawn with liberty is prayed for. Weekly. And where have we left off?
Weekly list. Item number 129.
Weekly 129.
129.
Weekly list.
Weekly.
129.
Challenging the award, my lord, passed by the labor court, my lord. Limiting the date chart. The lordship may kindly see on 9/3/1974, my lord, the opposite party number 2 was appointed as shop assistant. During his incumbency at different branch offices, number of disciplinary proceedings and dispute cases were instituted against him. And para 3, I have given the details of the disciplinary proceeding and dispute cases, my lord. Annexer 2 series and Annexer 7 series of the rejoinder affidavit. And in 2001 and 2002, there was accumulated loss of near about 50 crores. And it was on the verge of closure, my lord. Thereafter, a decision was taken to downsize the staff of the corporation by giving compulsory retirement under Rule 38 of TDCC Employee Service Rule 1990. And pursuant to constant service records, 21 employees along with the opposite party number 2 were given compulsory retirement under Rule 38.
So he is already superannuated now.
My lord?
My lord.
He's already superannuated now. You can't put him back. I'm saying you can't implement the order of the labor court.
Yes.
He is already superannuated.
He is already superannuated.
Then what is left? Only that monetary benefits.
No, under Rule 38, my lord, the compulsory retirement was given.
No, I know that. What is the effect of the impugned award?
Your lordship may kindly see. Your lordship may kindly see Annexer 3. Annexer 3 at page
53.
Annexer 3.
So only back wages.
Annexer 3 at page, your lordship may kindly see.
Sir, just come to page 53, sir.
53.
Para 12.
Yes, para 12.
Read it.
As it appears that the workmen were working under first party management with effect from 1/3/74 and continued his work till his compulsory retirement with effect from 13/9/2003. Before his superannuation, the workman has claimed the salary and other service benefits from the date of his compulsory retirement till his superannuation. As already discussed, the termination of service of the workman by the management was not legal. And this order has been passed on the finding that as if the order of compulsory retirement was passed pursuant disciplinary proceeding as a punishment, my lord. It is not that, my lord. Under service rules, my lord, 38.
Sir, let's read. Your arguments you can make later.
Yes,
just read the whole thing, sir.
Yes. Therefore, the workman is entitled for back wages for the said period. Considering the above facts and circumstances of the case, I am of opinion that it will meet the ends of justice. It is ordered for payment of back wages to the workmen. Thus, the reference is answered on contest against first party management without cost. Accordingly, the action of the management by way of compulsory retirement of the second party workmen from the service with effect from 3/9/2003 is illegal and unjustified.
So what is the back wages is for what period? What is his normal date of superannuation and which was the normal date of superannuation?
Normal date of superannuation, your lordship may kindly see 3/30. 2006, your lordship may kindly.
36, 2006.
36, 2006.
So matter of less than 3 years, sir.
My lord.
Back wages for 3 years. Why are you contesting? No, back wages for 3 years.
No, it has been passed on the finding that as a way of punishment, it has been passed, my lord. And 24 other employees, my lord, they have.
And you've also paid him. You've got some salary pursuant to the interim order.
Has been deposited.
It's been deposited here.
My lord.
And your lordship may
say it won't be treated as a precedent, sir.
Your lordship may kind of decision of this the Supreme Court recent decision, my lord.
What does it work out, sir? What is the amount? What have you deposited here?
Man,
what is the amount deposited?
That amount is deposited, but the order is.
Let us see. It's the waste of a lot of money for nothing.
Well, after
162? 1,62,000, sir. What is all?
Well, after considering the After considering the service record, my lord,
You will be spending you will be spending much more on litigation, sir. This is what happens when unthinkingly everything is challenged. Everything is challenged.
When a law is well clear, your lordship knows that compulsory treatment on the basis of service records, my lord.
Very good questions of law will deal with some other case. All right. This is only some 3 years and comes to 1,62,000. Nothing. You see, the challenge by the appellant in the present writ petition is to an award dated 18 November 2014, passed by the Labour Court, Jaipur, Corrupt, in industrial dispute case number 3 of 2010. Paragraph. The following dispute was referred to the Labour Court for adjudication. Take from page 44. Paragraph. The Labour Court has held in favor of the workman by holding that his compulsory retirement by the petitioner management with effect from 30th September 2003 was illegal. Stop. However, since by that date, the workman had already crossed the age of superannuation. Bracket 36 2006.
36 2006.
Bracket 36 2006. Bracket. He was only given the relief of back wages between 1st October 2003 to 36 2006. That is less than 3 years. Paragraph. While directing notice to issue in the present petition on 30th March 2016, this court required, as an interim measure, the petitioner to deposit the aforementioned back wages.
I have deposited 1,62,492.
Yes. With the registrar bracket judicial in the shape of a bank draft, which amount was to be kept in a return deposit with a nationalized bank. Paragraph. Pursuant to the above order, the petitioner has deposited in this court by way of a DD a sum of rupees
1,62,492,
which has been kept in a term deposit. TD. Paragraph. Learned counsel, the petitioner urged that the Labour Court erroneously proceeded on the basis that the compulsory retirement was as a result of disciplinary proceedings, when in fact it was not. Full stop. He submitted how the compulsory retirement was in terms of Rule 38 of the TDCC Employee Service Rules 1990, and the workman had been paid 3 months' salary, which he had accepted without protest. Full stop. He had in fact raised the industrial dispute more than 5 years thereafter. Full stop. Accordingly, it was submitted that the Labour Court's impugned award ought to be set aside. Paragraph. The court is not inclined to interfere with the impugned award since the workman having already reached the age of superannuation way back on 30th June 2006, and the differential wages being for a period of less than 3 years, and the amount itself not being very significant. It does not appear to be just and proper for the court to interfere at this stage. Stop. The concerns of the petitioner will stand allayed if it is made clear that the impugned award of the Labour Court will be treated as being in the peculiar facts and circumstances of the case, and will not be construed as a precedent for any other case. Stop. It is so ordered that the petition is accordingly disposed of. The amount deposited in this court, together with the interest accrued thereon, be released in favor of the respondent workman upon proper identification.
Item 130.
Item 130, my lord, petitioner has purchased a piece of land in the year 2009 under Annexure 8. Originally, the land was given on lease to one Ramu Maji in the year 1969 by WL number 374/69 under Annexure 5. After 14 years, Ramu Maji sold the land to Padmaja Das.
But you purchased it after the decision of the ADM. The impugned order is 7 December 2012, and you purchased this under registered sale deed of which date?
30/12/2029.
29?
No.
Date of purchase.
Pardon, my lord.
Date of purchase by you.
29. 30/12/2029.
2029. What are you saying?
Yes,
We are
my
in
lord.
2023.
Sorry. 2009.
All right. On the short ground that no notice was issued to the petitioner, who is supposed to have purchased the land in question from the on what was the date she said? 30th December 2009 by the impugned order dated 7/12/2012 of the Assistant Settlement Officer Bhubaneswar. The said impugned order is hereby set aside. What is the case number? That's not clear. No, the Assistant Settlement Officer will not be approved case.
Annex of 1 is additional settlement officer, commission sub-collector.
Corresponding appellate order dated what's the date of the appellate order of the additional sub-collector?
Appellant order 11/7/2006. High Court order.
No.
12/7/2013.
ADM order.
Of the additional sub-collector. Is also hereby set aside. Stop. As a result, objection case number 1728 will stand restored to the settlement officer. Will stand restored to the file of the Assistant Settlement Officer, which is this jurisdiction. Which place is it? Vijaypur, Brahmapur, Puri district. Or Khurda.
This would be
7/12/2012.
No. Which is this ASO of which place? 7/12/2012 ASO of which place?
ASO.
Which place ASO?
Bhubaneswar.
Let's put the file of ASO of Bhubaneswar, where it will be listed on 3rd April 2023. On that date, the petitioner will appear along with the downloaded copy of this order. The ASO will examine the matter afresh and pass appropriate orders in accordance with law within a period of 3 months thereafter. Till such time, status quo as of today shall be maintained. The writ petition is disposed of. Right. After lunch.
Specialist item number 1.
Lords, I have 2 minutes time, Lords.
All right. Please, sir.
All right. I just wanted to add one judgment, Lords, and draw your Lordship's attention to some facts, Lords. Not more than 5 minutes, Lords. Lords, the judgment which I wish to cite is 1996 1 SCC 597,
Yes.
Kerala State Felicity Board.
All right.
Kindly have paragraph 4, my lords.
Yes.
Or just 4-5 lines above that, para 4. The Kerala High Court by common judgment dated 19/12/85 struck down the revisions of tariff by the board. The respondent company and other consumers were therefore entitled to the refund of excess amount on the account of payment of revised tariffs. High Court Kerala directed that such amount paid in excess would be adjusted towards future bills to be issued by the board. The board thereafter moved this court by filing special leave petitions inter alia challenging the correctness of the judgment of the Kerala High Court dated 19/12/85, striking down the revisions of tariffs. Such special leave petition was entertained by this court and an interim order was passed, inter alia directing that pending disposal of the appeals before this court, there would be stay of the refund of charges already collected. It was further directed that this court that future charges would be collected to the extent of 50% only, and the balance would be adjusted towards the past charges. The respondent company paid 50% of the demands for the months of March to June 86 and adjusted 50% of the balance towards the refund due to them. Similar appeals were also preferred by the State Legislative Board against other consumers whose writ petitions were disposed of by the said common judgment by the Kerala High Court. All the appeals preferred before this court were allowed by this court by judgment dated 26/8/86, upholding the validity of revisions of tariffs by the board. In view of the said decision of this court dated 26/8/86, upholding the tariff revisions by the board, the respondent company and other consumers became liable to pay the amounts due on the basis of revisions of tariff, including the amounts since adjusted by them in the manner indicated herein before. The board thereafter issued a demand for payment of the amount by the respondent inclusive of interest at 18% per annum. The respondent company did not challenge the liability to pay the excess amount in view of the revisions of tariff, but it refused to pay interest as demanded by the board, and such claim of interest by the board was challenged before the Kerala High Court by filing a writ petition number so-and-so. The learned single bench disposed of the writ petition by holding that the demand of interest comprised in the demand notice was not justified and the demand of interest of a sum of rupees so-and-so as contained in Exhibit P2 was squashed. The board preferred appeal, but the appeal was also dismissed at the bottom. The Lordship will find last 2 lines. So I'm skipping that note. Kindly come to paragraph after noting arguments at para 22. After giving our careful consideration to the facts and circumstances of the case and submissions made by the learned counsel for the parties, appears to us that revisions of tariff for the electricity charges payable by the company and other consumers had been struck down by Kerala High Court. So long such decision was not revised, the same, even though erroneous, remained fully operative. The result was that no bill could be drawn by the board on the basis of revised rates, and even if such bill had in fact been drawn, such bill remained inoperative during the entire period when the judgment of Kerala High Court had governed the field. Pendency of appeal before this court only ensured that the proceedings had not been finally concluded. But in the absence of any interim order of this court granting stay of operation of the impugned judgment, the judgment of the High Court was binding between the parties to the list despite pendency of the appeal. Viewed from this aspect, it is quite evident that the company, or for that matter, similarly placed consumers, had no obligation to take notice of the revised tariffs and to make any payment on the basis of such revised tariff. Consequently, the company cannot be held to be a defaulter for non-payment of the enhanced rate during the period when revisions, though made, remained unenforceable on account of the decision of the High Court. I'm only emphasizing that sentence, not in the absence of the interim order. But after the decision of this court upholding upward revisions of tariffs, the board's entitlement to draw bills on the basis of upward revisions and consequential enforceability of payment of such bills by the consumers revived with full force. Hence, it would not be correct to contend that although the company, or for that matter, other consumers, were required to pay on the basis of revisions of tariff from the dates when such revisions became effective, liability for such payment would accrue only from the date of the pronouncement of the judgment by this court, upholding upward revisions, and not from the date prior to that. If the upward revisions are held as valid, enforceability of such upward revisions being consequential to such revisions, though it had remained unenforceable for some period, on account of the decisions of the High Court, cannot but revive from the dates of upward revisions. There is no manner of doubt, it is an imperative duty of the court to ensure that the party to the list does not suffer any unmerited hardship on account of an order passed by the court. The principle of restitution, as enunciated by the Privy Council and Roger case, has been followed by the Privy Council in later decisions, and such principle being in conformity. May I proceed, Manoj?
Yes.
It will be the endeavor of the court to ensure that a party who had suffered on account of decision of the court since finally reserved should be put back to the position as far as practicable in which he would have been if the decisions of the court adversely affecting him had not been passed. In giving full and complete relief in an action for restitution, the court has not only power but also a duty to order for mean profits, damages, costs, interest, etc., as may deem expedient and fair, conforming to justice, has been done in the facts of the case. But in giving such relief, the court should not be oblivious of any unmerited hardship to be suffered by the party against whom action by way of restitution is taken. In deciding appropriate action by way of restitution, the court should take pragmatic view and frame relief in such a manner as may be reasonable, fair, and practicable, and does not bring about unmerited hardship to either of the parties. In the instant case, the company and other consumers, though have liability to pay on the basis of revised tariffs, they had not paid on such basis because of erroneous decision of the High Court. Not only they did not pay on the basis of revised tariffs, but they got adjustment of payments already made prior to the decision of the High Court against future bills to be drawn only on the basis of unrevised tariffs in a phased manner. The company is an ongoing business concern and must have utilized the money saved on account of the decision of the High Court gainfully in its commercial activities. Similarly, other consumers have gainfully utilized the amount saved for being not required to pay on the basis of revised tariff. The board had to suffer financial loss because of the said erroneous decision of the High Court. In the aforesaid circumstances, it will be lawful, conforming to equity and well-established principles of restitution, to claim interest at 18% on the unpaid portion of the bill drawn on the basis of revised tariffs. Company had agreed to pay interest at 18% on the bills if not paid when they became due. Even otherwise, claim of 18% interest appears to be just and proper. So therefore, my lords, this is a case which says, my lord, that because of the principle of restitution, compensatory, and that flowing from the fact that they have kept that money, and may I submit this, that in most of the petitioners, in fact, they have not even pleaded, my lord, that they had not recovered the money from the consumer. And your lordship will recollect that they were filing return consistently. In the return, full amount, my lord, was being shown. Full turnover, full amount payable, but they said in view of Supreme Court, we are paying less. So they had recovered from the consumer, my lord, entire amount, and they kept it. So it is tax money which they kept and utilized for gain. Now, that being the circumstances, my lord, the question will arise whether such a litigation such a course of litigation, Lord, irrespective of what interim orders were passed, once they lose, Lord, then they can't get out of this liability of interest merely by referring to sufficient cause. Hence, my submission was that litigative course of action, my Lord, cannot be a ground to justify sufficient cause. So that's the judgment which I wanted to cite, my Lord. And if your Lordship has page 24 of the written note filed by the state, my Lord. My Lord, some of the petitioners had filed petitions directly to the High Court. Since the Supreme Court said that, your Lordship will recollect that Supreme Court said in the interim order.
Right.
Now, this is an alternative submission which I am making, my Lord, without, on an assumption, my Lord, that my submission doesn't find favor, my Lord, then.
Right.
So, your Lordship will recollect that interim order said that the interim arrangement will be applicable only to those petitioners, my Lord, who were before the court. Rest were allowed to, my Lord, liberty to file. So some of them came to the High Court and obtained, my Lord, some certain interim orders which are of a different character.
Yes.
Now, please see page 25 of this note.
Yes.
Now, since where this clerk said that you pay 1/3 and the remaining 2/3 will be deposited in the nationalized bank. So these interim set of interim orders were different from the one which was passed by the apex court.
Yes.
Now, since the amount has been deposited, the entire amount in the bank with interest has to come back to the state. This can't be a case where it can be said that because of any interim order, etc., passed or any influence flowing from the interim order of the apex court, the liability was not there. All those factors were in submission and be that we get the tax and they get back the interest.
Yes.
Yes. Because there the deposit is virtually of the full amount. Such deposits and banks are always treated as payment. I sent out a number of cases. I'm not reading all the models, they are in the same refrain. That the disposal of the Supreme Court, that the Supreme Court was in 2017, the 9 judges' judgment had come in 2016 November. It's a matter of only 3 months or 4 months. The judges' bench which disposed of the writ petition, it has done nothing except to say that the question has been already decided by the 9 judges' bench. Your Lordship, we try to recollect that word, then the judgment is a 2-page judgment. It's the next question. We have a page 5, judgment.
Yes.
And please come to page 107.
Yes.
At the 30th of has been quoted, then the court says at the end at 108, a process issue involved in this stands decided by the 9 judges bench. So a case was after the 9 judges judgment, which is of November 2016. The position was settled by the 9 judges judgment itself so far as para 30 is concerned. This is merely a disposal in the light of that judgment.
Right.
As far as the legal issue regarding the validity of the observations in para 30 is concerned, then it was settled by the 9 judges judgment. These are the 3 things that I wanted to add.
All right. All right. Yes, Mr. Mishra.
Sir. Before I start to reply, if Lordship looks at page 286 of the brief, 286. Paragraph 4, continuation top, It says, though the petitioner denied the contention of the counter affidavit as stated in different paragraphs, but more particularly, it has been averred in paragraph 6, 17, and 18 that the petitioners had recovered entry tax and the sale price includes the entry tax, and the entry tax burden has been shifted to the consumer third parties, which is clearly denied by the petitioners inasmuch as the aforesaid averments are erroneous, capricious because of the fact same is not supported in the material evidence on record. At no point of time, the entry tax was recovered from any of the customers, and the same price did not include, sale price did not include the entry tax. Therefore, when the petitioner had not recovered entry tax from third party at any point of sale, it is quite unreasonable on the part of the opposite parties to say that the same was not accounted in the balance sheet. We have specifically stated that in the, now coming back to the reply.
Yes.
I would like to take your Lordship's few orders passed by the Honorable Supreme Court, Merit. So kindly turn to Annexure 2, Merit.
9 July.
Yes, Merit. Sorry. 86. Page 86, Merit starts.
92, I think 91, 92.
The page 88, Merit, Annexure 3. But this batch of writ applications filed by the state, it is SLP 14454 to 14778 of 2008. Top Mallet, it is there. Page 86, top Mallet, Annexure 2. Page 86, Annexure 2. The state of Orissa versus Reliance Industries Limited, Mallet, with prayer of interim relief. Why I am trying to bring your Lordship's notice all these things? Because the interim application was filed by the state, not by the parties. Then, sir, if your Lordship comes to Annexure 3, as page 88, second line of the after the cause title, IN number 327 to 651. That relates to the interim application filed in the SLPs filed by the state. These are page 92. the portion which has marked has become a little bit black, my lord. IN number 327 to 651. Lord God, in the middle of it.
Yes.
That relates to the batch of interim applications filed by state in those SLPs where the order has been passed. Pending further orders, there shall be stay of the impugned judgment till further orders in terms of prayer clause A to the extent held in paragraph 30, which reads as under, the state has no jurisdiction to impose tax of such goods imported from outside and are not manufactured within the state of Orissa. Therefore, the opposite parties may make scrutiny of the same and not to realize entry tax on such goods. In the meantime, let me kindly mark here the important part of it. This group of Orissa matters is adjourned for a period of 3 weeks. It is made clear that the state will submit the cutoff date for the simple reason that this court intends to record that each and every assessee in this group intends to record, because in the future date it will be given effect to, intends to record that each and every assessee in this group of cases shall pay outstanding amount as of cutoff date in installments within the time fixed by this court. Secondly, it is also made clear that if the state ultimately loses, it shall refund the amount with interest, which shall be fixed by the court at the time of final hearing of these matters. However, each and every assessee in this group of cases shall undertake to pay the outstanding amount in installments with the current liability that may accrue pending disposal of these special leave petitions. It is further made clear the assessee in this group of cases will have to deposit the outstanding taxes without penalty. This was the proposal that was thought of by the Honorable Court to give in the next date, madam. This is not operative order itself. If your Lordship looks at the subsequent order, that is page 95, Annexure 4.
Yes.
The effective order was stay operation of the order. The Annexure 4, madam. Top, it is there, IN number 327, 651. I got that top, madam. Interim applications.
Yes, yes.
The order is, the Lordship, at the page 94. They have also taken note of different cases, 3 to 2010, different cases. There are 2 batches of cases in this group. But this is Bhushan Industries, the manufacturers were there. Bhushan Industries, then Vedanta Limited, Aluminum Limited, then Reliance Industries. Those are manufacturers. Their cases have been dealt in the first part. That is part A and part B. So if your Lordship looks at, there they have the Honorable Court directed, Supreme Court directed, paragraph 2 at page 98. In this case, concerning Bhushan Steel and Stripes, according to the department, as on 30th September 2009, an amount of 38.79 crores approximately is due and payable under the impugned law. At this stage, we are of the view that SSC should deposit under protest with the department a sum of 7.5 crores out of 38.79 crores before 31st March 2010. This amount is calculated by us on the footing that the SSC has already paid till date an amount of 8.42 crores. As far as current liability commencing for 1st of October 2009 is concerned, the SSC will pay the entry tax as on an ad hoc figure of rupees 30 lakhs per month. This amount is payable as per paragraph 30 of the judgment of the Honorable Court, which is under challenge. As far as the item which is not covered in paragraph 30 of the impugned judgment concerned, liberty is given to the SSC to move separate interlocutory applications. Before concluding, we may mention that the state of Orissa will file an affidavit undertaking to refund the amount to the extent of the state losing in the event of the state losing its case, with interest to be fixed at the final hearing of the matter. But this order has been passed in all those manufacturers' cases, my lord. This is not the traders. Am I clear, my lord? So far as the traders are concerned, you should kindly turn to page 101. it starts rest of the interlocutory applications.
Right.
So those interlocutory applications also relates to filing by the state, not by the parties. In this batch of interlocutory applications, the department has furnished to this court names of traders. In list A, a name of manufacturers in list B, excepting Messrs. Bhushan Steel Stripes and Bhushan Energy and Vedanta Aluminium Limited and Reliance Industries Limited, whose cases we have dealt separately. They have already dealt separately, who are required to pay entry tax up to 30th September 2009. Both these lists are covered by paragraph 30 of the impugned judgment. The list reads thus, but so far as the petitioner's case is concerned, it is serial number 20. If you look at in the list, list A, traders, serial number 20. Let's we kindly turn to page 102.
Yes.
The operative portion of that now comes, having regard to the outstanding amount in list A and list B mentioned here and above, we are of the view that each of the SSC will, without prejudice to its right, deposit with the department 1/3 of the outstanding amount indicated in list A and list B as on 30th September 2009 before 31st March 2010. Each of such SSC will also continue to deposit with the department the outstanding amount on the basis of the current liabilities which are accrued after 30th September 2009 at the rate of 33.5, 1/3, that is 1/3 of the amount due to the monthly return which each of the SSC has been filing with the department. It needs to be clarified that this order is confined to cases falling under paragraph 30 of the impugned judgment. As far as the item which is not covered in paragraph 30, it's concerned, liberty is given to the SSC to move separate interlocutory applications. Before concluding, it may be mentioned that the state of Orissa will file an affidavit undertaking to refund the amount in the event the state losing its case with interest to be fixed at the final hearing of the matter. Such an undertaking will be given by the Chief Secretary of the State of Orissa of the state. We make it clear the amount which are to be directed, we are directing the SSC to pay shall be treated as a deposit, not as a tax, till hearing and final disposal of the matter. The interim order passed by this court on 30th October 2009, to the extent indicated above, stands modified. But the stay that was passed stood modified by virtue of the order passed by subsequent order. But if your lordship looks at, subject to above, these interlocutory applications are accordingly disposed of. But my respectful submission here is, if your lordship looks at, the paragraph 30 remained, even if the interim order was there, that was modified here, and paragraph 30 itself stood operated, it has not been obliterated. But the arrangement that has been made is a modality that has been fixed, that it will not be construed to be tax, but the return we should go on filing, and as per the return, the amount of 1/3 shall be deposited. And that is the reason why we continue to deposit, comply the order till the final order has been passed. So my respectful submission is that by reading, on a close reading of this, it transpires that paragraph 30 remained till the final order. Because stay order doesn't take away the effect of it, number one. And the modification order itself clarifies that paragraph remains. The arrangement has been made that state should get some benefit with regard to the money that has to be deposited. And interestingly, that deposit is not deposited in the
Consolidated
not consolidated fund. Because if it is consolidated fund, it cannot be refunded. It goes as a tax. Therefore, it will be kept deposit separately. And in the event the state loses, they will return it with interest. If we lose, it will be adjusted. But my respectful submission is that once paragraph 30 remains till the end, there is sufficient reason which is not there in any of the cases. The cases cited by my friend, actually, all those cases relates to stay operation of the judgment, subsequently it has been lifted. None of the provisions of the statute speaks about sufficient reason being shown. If your lordship looks at 7.5, and have a look at 7.5. Such language is absent, conspicuously absent in other statutes. So, for 5 minutes of section 5,
Yes.
where a dealer requires to file return under this section fails without sufficient cause. This is the most important line which is there in the statute itself. Fails without sufficient cause to pay the amount of tax due as per the return of any tax period, or fails to furnish return, such dealer shall be liable to pay interest in respect of one tax which is failed to pay according to the return. But one thing I would like to bring your lordship notice, number one is sufficient cause. Number two is these are not been construed to be tax. The Honorable Supreme Court was conscious about the statute. They knew that it cannot be considered as a tax because 7.5 may not be applicable and they may not be liable to pay tax. Once we are not liable to pay tax, even if then interim management has been made, paragraph 30 remained. Once the paragraph 30 remains, my lord, the amount we deposited can also be considered to be taxed during the period till the matter was pending for adjudication. So it is not to be considered as a tax. Number two, there is sufficient reason for non-payment because of the arrangement made by the Supreme Court, and paragraph 13 remained. But why paragraph 13 remained? If you also kindly see the decision. Yesterday, this decision actually has been referred to in another decision. This Chamundi Moped Limited.
Oh, I see.
92 Supreme Court, Volume 3, SCC. Paragraph 10.
Yes.
In the instant case, the proceeding before the board under section 15 and 16 of the Act has been terminated by the order of the board dated 26 April 1990, where the board, upon consideration of the facts and materials before it, found that the appellant company had become economically and commercially non-viable due to its huge accumulated loss and liabilities and should be wound up. The appeal filed with the appellate company under section 25 of the Act against the said order of the board was dismissed by the appellate authority by order dated 7 January 1991. As a result of these orders, no proceeding under the Act were pending either before the board or before the appellate authority on 21st February 1991, when the Delhi High Court passed the interim order staying the operation of the order of the appellate authority dated 7 January 1991. The said stay order of the High Court cannot have the effect of reviving the proceedings which had been disposed of by the appellate authority by its order dated 7 January 1991. While considering the effect of an interim order, staying the operation of the order under challenge, the distinction has to be made between quashing of an order and stay operation of an order. Quashing of an order results in the restoration of the position as it stood on the date of passing of the order which has been quashed. The stay of operation of the order does not, however, lead to such a result. It only means that the order which has been stayed would not be operative from the date of passing of the stay order, and it does not mean that the said stay order has been wiped out from existence. The said order has been wiped out from existence. This means that if an order passed by the appellate authority is quashed and the matter is remanded, the result would be that appeal which has been disposed of by the said order of the appellate authority would be restored. It can only be said to be pending before the appellate authority after the quashing of the order of the appellate authority. Same cannot be said so far as for an order of staying the operation of the order of the appellate authority, because in spite of the said order, the order of the appellate authority continues to exist in law, and so long as it exists, it cannot be said that the appeal which has been disposed of by the said order has been disposed of and is still pending. We are therefore of the opinion that passing of the interim order dated 21st February 91 by the Delhi High Court, staying the operation of the order of the appellate authority dated 7 January 1991, does not have the effect of reviving the appeal, which has been dismissed by the appellate authority by its order dated 7 January 1991, and it cannot be said that after 21st February 91, the said appeal stood revived and was pending before the appellate authority. So my respectful submission is that, but para 30 remained till it is set aside by the Honorable Supreme Court. The interim order of stay has been modified to the extent that has been done by the Honorable Supreme Court. But there was sufficient reason for which the 2/3 could not be paid. We could not have paid, but it was argued with due respect, that we could have deposited the entire amount collected. We could have deposited as per the return, but it has not been considered to be a tax. But we have said you have to deposit 1/3. So there is a specific order to that effect. And paragraph 30 is still staring. And my respectful submission is that, therefore, the question of deposit of 2/3, the pendency of the appeal matter before the Supreme Court doesn't arise till the Supreme Court passed the order. Yes, after passing of the Supreme Court order, we are bound to pay the amount. Because the Supreme Court said, no, it's applicable, 30 has been taken out. The order passed by the Honorable High Court has been set aside and quashed. This is so far as the first part is concerned. But therefore, once this is not considered to be a tax, once the Honorable Supreme Court has passed an order, question of paying that doesn't arise. And there was sufficient reason, which is silent so far as the other statutes are concerned, is staring so far as the present case is concerned, then we have sufficient reason to show that why you did not pay.
What about the cases where parties came to this court and got a stay? Is there any difference? Because in page 42 of that written note of the state, you see the written submission. I think they're trying to make a separate category for those who came to this court and got a stay in terms of the reliance order. You see page 42, that written note.
Page 25 minutes.
That is very important.
Para 12.
Yes.
Division para 32 view 9
High Court. Your Lordship referring to WPC 19411?
No, all this, the written note of submissions, which the other day was handed over.
Notes, just.
Actually, my lords, there were two categories. Around 600 to 700 dealers matters were heard. On a single day, one judgment was given, and the next day covering that, the other judgments were passed. So this particular batch, the state went on an SLP. The other batch, where para 30 was excluded, they did not went on an appeal. That remained as such. Still, this 33 1/3 order came into force. As per paragraph 30, the other batch of applications, they were completely excluded from the purview of paying the entry tax.
I think this other batch they're referring to.
And following the Supreme Court decision later on, 33 1/3, this Honorable High Court, because what happened?
So that is what they're referring to.
That is what they're referring to, that paragraph 30, automatically all those goods which were not manufactured within the state of Odisha, they stood excluded. So after this, the manufacturers were actually in difficulty. They had challenged the act as ultra-virus. When the act was held as intra-virus later on, then the difficulty came, the manufacturers were liable to pay. So the manufacturers also went and appealed. Those 4 to 5 manufacturers.
taking into consideration all these applications were passed category wise. One list, they said the manufacturers, which was completely stayed. They said, no, since the outstanding liability is huge, they were given installments, which my learned senior was argued as a workable arrangement. It was never a workable arrangement. By way of paragraph 30, entire list excluded those goods which are not manufactured within the state of Odisha. Following these Honorable Supreme Court decisions, the traders also went on an appeal, those who had not gone to the Supreme Court, in view of the order that the exclusion given by the Honorable Supreme Court, that those who are not before this Honorable Apex Court, they can approach the authorities. So accordingly, all these petitioners, they moved before this Honorable Court, wherein following the order of the Honorable Apex Court, these orders were passed 33/1/3. And these 33/1/3 remained as such till the modification came up into year 2017, where we were called upon to ask interest. So therefore, in one single lot, in a cyclo-style manner, they served us the notices that you go on paying after 31/3/2017. By virtue of that, we went on paying the interest in installment was sought for, and also so far as the outstanding tax installment was sought for, and all of them have complied. They have paid. So there was no deliberate withholding of tax or anything, no unjust enrichment. We have just followed the guidelines as per the Apex Court and the Honorable High Court. And even in Honorable High Court, I will tell your lordships, if the state is called upon, they did not file any application for vacation of stay also here. They simply served us notices that, and so moto the delayer went on complying in spite of the order of stay in the Honorable High Court. That has also happened, my lords, in number of matters. In number of matters also, they did not file any vacation of stay petition, but notices were served and we went on complying with the direction.
Yes, but
the early High Court order you are passing.
That High Court order you are referring to, I am giving that, my friend.
Not just.
But if your lordship looks at page 107, 107, the operative portion of
In
the
my
order.
case, Lord, I have, in compliance with High Court order, I have paid the tax and penalty, everything I have complied with. I am giving the order of the High Court order. There's two type of, your lordship rightly pointed out, there's two set of dealers.
Those
Some were not complying the Honorable High Court's order, relying upon the Supreme Court order.
When the Supreme Court judgment was pending, these orders were passed.
And we are complying this order. And in my case, my lord, I have paid the tax and interest also.
All right. But that, if your lordship looks at the High Court order, is 11/10/2012.
Right, correct.
But paragraph 107, if your lordship looks at,
Yes.
it says we may mention that certain aspects have been decided against the SSC by the High Court, and the SSC have preferred these appeals. These appeals, those batch of cases where SSC also filed prior to that, those appeals shall be decided on their own merit. The government has come in appeal, challenging the conclusion of finding in part 2 of the above, where the High Court has held that state cannot impose tax on the goods imported from other states and not manufactured and produced within that state. Then quoted paragraph 30. Next page, the aforesaid issue involved in this appeal stands decided by the 9 judges bench by the Jindal Stainless Steel Limited in so-and-so in favor of state. Accordingly, these appeals are allowed. This is 28th March 2017. So these High Court orders were during the pendency of those cases. So this order will definitely bind actually so far as those cases are concerned.
In view of the order of the Apex.
Because it says that in view of the order of the Apex Court dated 3/2/2010, passed in IS so, we are directed the petitioner to pay 1/3 of the area dues, would computed up to 30th September 2012, and be paid by the end of October 2012. The order of arrear and current liability with effect from October 12 onwards. The petitioner will go on paying 33.5% from October 12, along with return. For the balance amount, the petitioner shall furnish indemnity bond before the authority. We made it clear that the amount which is directly paid shall be treated as deposit, not as a tax till final decision taken by the Apex Court. However, the aforesaid payment is without prejudice to the rights of the parties. But therefore, and another decision, if you also looks at the decision cited by my friend, that is, but as much emphasis was given.
My lord, can I pass on an order?
Just a minute. Jutes not required.
Correct.
Page 5 of the.
Correct. Calcutta jute manufacturer.
Right.
No, not only Calcutta, Kanoria, Indian Council for Environmental Legal, Rajasthan Housing Board.
But actually, main this Calcutta is the main decision where actually that JK synthetic has been distinguished, saying that not applicable.
Right.
But in that matter, if your lordship looks at, during the pendency of the proceeding, amendments were made to the statute itself.
Right.
A burst and arrow burst. One second. Arrow burst again.
Actually, the statute is in para 4.
Yes, Manoj.
10A.
No, wait a minute.
Page 8 of the compilation.
Paragraph 4, Manoj.
Yes.
The West Bengal Taxes Tribunal, before which the appellant challenged the demand for payment of interest, dismissed the petition filed by the appellant for considering the efforts of contention of the appellants on perusal of section 10A, capital A, is necessary. 10A of the Act reads thus: where the registered or certified default dealer furnishes a return referred to in section 10 in respect of any period or prescribed date of thereafter, but fails to make full payment of the tax payable in respect of such period by such prescribed
Just stopping here. So this is the point I think you're making.
He shall pay
it
simple
simply says
interest.
fails.
Right.
Doesn't say fails without reasonable cost.
Yes. But if lordship looks at, there has been an amendment to that effect. And you look at paragraph. And then that statute also silent so far as the sufficient cause part is concerned.
Subsection 2, subsection.
Paragraph 12.
Fails.
They have distinguished that JK synthetics. The counsel of the next contended alternative that in view of the decision of the constitutional bench, JK synthetics, the appellant cannot be diluted with interest on the tax amount since they were bona fide contending in contesting the validity of section 6B of the Act. This contention warrants serious consideration. They have said in last but 2 lines, JK Synthetics filed return on the premises that the amount of freight charges in respect of sale of cement as per the cement control order didn't form part of the sale price for the purpose of payment of sales tax. That contention was rejected by the court in Hindustan Sagar Limited, Mills Limited. On the strength of the said decision, JK Synthetics was required to pay sales tax on the sales price inclusive of the freight. The dispute then arose whether the company should pay interest from the date of filing of the return or only from the date of determination of tax payable in the final assessment. Revenue then contend that interest became payable from the date on which the original return was filed under section 7.2 and 7.2a of the Rajasthan Sales Tax Act. The said contention was based on another earlier decision of the bench of 3 judges bench and that Associate Cement and CTO. But that finding has been court given. They have distinguished subsequently like the paragraph 14 that the majority view expressed in Associate Cement's case was overruled and the minority view was upheld by the Constitution bench. But the position here is explicitly distinguishable from the factual situation of JK Synthetics. Nobody had doubt that section 6B of the Act was valid. The tax was payable on the turnover. It was the constitutional validity of section B which was challenged challenged by the appellant in the earlier writ petition before the Calcutta High Court, and which was finally ended up in affording its validity. Hence, there was no question of assessee waiting for the determination of the turnover. There was no dispute on that aspect. The fact that appellant questioned the constitutional validity of the challenging provision cannot be equated with a dispute whether the freight paid would also form part of the sale amount. It was a highly debated dispute whether the price amount would envelop the freight charges paid by the dealer until the controversy was resolved by the court in Hindustan Sugar Mills. The dealers were justified in excluding the freight charges from the sale price. It was for the reason the Constitution refrained from mulcting the taxpayer with the liability of pay interest liability additionally. Appellant in these cases never disputed they are liable to pay tax on the turnover under 6B of the Act with even while the focus on the view, the proviso. But in the Calcutta case, the one new statute was incorporated during pendency. That was never challenged. Virus was challenged by the SSC. Here, actually, the High Court gave its finding in favor of the SSC. The state challenged it. So those are the distinction, and most primarily, there was a charging section which was incorporated. In our case, 7.5 is the only section which is the charging section. There is no separate charging section as such. And that is not applicable because the sufficient cause is absolutely there in the provision why it was not paid at the relevant time. Because the order, because of paragraph 30 and the order of the Supreme Court. So therefore, and all other decisions regarding stay and other things, but those I have clarified with the 92 Supreme Court, what is the effect of stay. And the effect of the order itself, paragraph 30 cannot be taken away or wiped away from the applicability, even if there is a stay order is there. Second part is, this is the first part of it, Lord. After the order was passed,
no charging section for that.
I brought it to a lot's notice. Once 7.5 is not attracted during the aforesaid period.
And then without a charging section, you can't.
Yes, charging section is not there. There may not be. So equity can be done, as your lordship can do it, but some amount can be directed to be paid on that. So that's a different aspect altogether. That's not bringing 7.5 into picture. That is exactly I wanted to. After 28th. So after 20th March, 7.5 has got no applicability. And that's only your lordship can fix an amount if your lordship feels like that. And we are paying the amount, but most of them have paid the amount, in fact.
Just indulge. Seek your lordship's kind indulgence, lords. Lords, in this batch of writ petitions, there are some writ petitions in which the parties have already paid the amount of tax along with the interest as directed by this honorable court. So I'd just pray for your lordships if we can place, return note of submission to that effect along with the date.
Sure.
So that it can be.
Lordship, permit me, I will make small additions only. Your lordship hard at length, Lords. Sir, I will be arguing from Lords WPC number 25219 of 2017 Lords. ACC Limited versus State of Orissa. Sir, in this case, my friend Mr. Dwivedi has brought your lordship's notice along with compilation a number of judgments, Lords. But the little I have gone through all, Lords. The first judgment in the Siliguri municipality case, Lords. It speaks of stay or interim order as a workable arrangement. The lordship will find from judgment the Honorable Apex Court all through was dealing with while exercising power under 226, but how the interim applications are to be dealt with. There are the institutional interests, all those are the concern of the Honorable Apex Court. So that has nothing to do with the present case, Lords. Absolutely, it has no relevance in the present context, Lords. Second matter. Calcutta jute manufacturing, which a little while before my friend Mr. Mishra was also addressed to Lordship. Because in that case, SSC, they have filed a return without disclosing the turnover, which was stated to be truncated returns, truncated returns. So those truncated returns ultimately ending up with actual disclosure of turnover resulting in tax demand. And Honorable Apex Court said, once there is quantum of turnover disclosed, and tax which was payable not paid bills, so you can't exonerate from tax liability. Those have also nothing to do with the present case bills. Without going through detail bills. Yes. Third matter, that Canoria Chemicals case. That was a case bills where interim stay of notification was granted bills. And after dismissal of writ petition, the question was whether the SSC can be relieved from the payment of surcharge bills. That was payable in respect of the turnover available to be taxed bills. So Honorable Court said yes, even though interim order was there, at the instance of the petitioner, which is not a case here also. As my lords knows, the 2008 judgment was in favor of all the associates lords. It is the state who being aggrieved challenged para 30 because that was the important paragraph which was prejudicing revolutionary interest. They preferred appeal and stay para 30 of the judgment was stayed, operational state. So that has nothing to do with Canora case lords. Then going by the next matter, Indian Council for Enviro Legal, that was a case of disgorgement of gains of polluter. If a polluter causes pollution and thereby gaining itself to the prejudice of other spirits, restitution of relief which was granted by the apex court pillars. So that also doesn't match with this. That's a civil liability and the restitution was granted.
See, I think the repeated submission was mere pendency of litigation does not provide sufficient costs. I think you must have said it several times. So what is your answer to that? Because this environmental legal thing, para 197, subpara 5, no litigant can derive benefit from the mere pendency of a case in a court of law. So what is being argued is...
Sir, can I explain that?
That expression without sufficient costs means some extraordinary sufficient cost. That is externality. I think Mr. Dwivedi used the word externality.
Externality.
So he says like some earthquake, some fire, something like that. But not just because I have a case pending in court, that is not sufficient cost. That's what he says.
But this is also not our case, sir. It is not that the case is pending, we are saying that sufficient cause. Because paragraph 30 is there, therefore that is the sufficient cause merit. We are not supposed to be liable to pay it. Paragraph 30 is here, which is distinguishable from other cases. Because here it is not that the case is pending.
And then the second thing he kept harping on is the expression restitution. He says, I should get back everything I would have got had these people not gone to the court. So if they have lost comprehensively in the Supreme Court, now I get back everything I lost.
In those cases where the assessee goes and challenges, tax is there. Assessee challenges gets and stay. Therefore, the amount is stayed. Here, that's the reverse.
The converse case.
Contrary. So these are the distinctions.
Sufficient cause. This aspect was dealt in by Calcutta High Court. Very plain words. Honorable Calcutta High Court has said. Paragraph 18 of that Asutosh Bhadra case. Just 2 lines.
Is it?
Sorry?
You've already given us.
No. I am giving. I have a compilation.
So you file it.
One line, Millers. The existence of sufficient cause. That is in relation to Miller's limitation, of course, Section 5. Is a condition precedent for exercise jurisdiction under Section 5 of Indian Limitation Act. Sufficient cause must be a cause beyond the control of the party, invoking the aid of this section. A cause for delay which a party could have avoided by exercise of the care and attention cannot be a sufficient cause. In other words, the court must be able to say, having regard to the facts and circumstances of the case, that the delay was reasonable. So therefore, not that in all cases, Millers. If there are reasons, reasonable cause, and due diligence exercise, your lordship Millers in the facts and circumstances of this peculiar case, Millers. My lords have seen many interim orders, Millers. Perhaps this is the only interim order passed with the Honorable Apex Court, which is the peculiar circumstances and peculiarly worded also. So with great respect, Millers, why it is peculiarly worded? Once again, I will bring your lordship's notice, Millers, the interim order 3/2010, only 2-4 lines from that judgment, from that interim order. Millers, 3/2010.
Yes.
Millers, initially, in all those 4 matters, in case of Reliance, Bhushan Steel, then Bhushan Power, Reliance Millers, Bhushan Vedanta Millers, in all those cases, my lords will see there is direction to pay ad hoc monthly payment. Can my lords perceive of a direction? You pay ad hoc pay of 30 lakhs. In some cases, there is direction to pay ad hoc pay of 10 lakhs, depending upon the volume of tax liability belongs. In respect of the liability accruing from para 30 of the judgment. There's no determination, nothing belongs. Go on paying 30 lakhs. Go on paying 10 lakhs per month. Ad hoc payment belongs. So, Honorable Apex Court has in mind, probably there is a strong prima facie case. Consequence, I am not Millers elaborating for lordship. What would have been Millers? Ultimately, maybe in 2017, we lost before the Honorable Apex Court lost. But in 2018, on the face of it, when the Honorable Apex Court found from para 30, while considering Article 304A mirrors and the enactment which they have claimed to have framed under Article 304A, which earlier state was claiming to be under Article 304B in IMPA case, suddenly they changed their stand. This is a bizarre case. Changing their stand from the source of enactment, earlier saying it's an enactment 304B, compensatory, all those elements are there, it traveled a lot mirrors. Now they changed their stand saying that in the enactment under 304A. And once they said so, on the face of it, mirror, on the court said no, 30 mirror said he could not have any legislative power to impose goods tax in respect of goods which are not manufactured in the state but comes from outside. In any case, my lords, so that is an ad hoc payment. Second, my lords went on saying that the money that will be deposited, that will not be taxed but deposit. State is permitted to spend that amount for public good. That liberty was granted, but the money which will be paid by the petitioners, that will not be taken to the constitutional fund. That will be there in a separate fund. Hardly, the lordship will see the very word which I was looking at, list A, list B. So one for manufacturer, one for dealers. Yes, minors. And while granting stay of 33,130 years, what the Honorable Apex Court has said, minors, the deposit with the such assesses, so it means the list A, list B assesses, such assesses will also continue to deposit in the department the outstanding amount on the basis of current liabilities, which has accrued after 30th September 2009. 30th September 9 is the cutoff date, mirrors. That is the cutoff date, the earlier order, which was modified by this order, mirrors. That stands modified, but that's the cutoff date. That means prior to 2009, this is not going to operate. Post 2009, mirrors, at the rate of 33.1/3% of the amount due in the monthly returns. Again, your lordship have to reconcile this with 7.5, because I am under obligation under rule section 7 to 5 returns. In the monthly return, which I am filing, as per this interim order passed with the Honorable Apex Court, maybe it's 100 rupees, but I will be obligated to pay while complying the order at 33.13%, the monthly return, which each of the assessors has been filing with the department. So your lordship can reconcile this section 7, relevant rules, and the interim order passed with the Honorable Court. Now, it needs to be clarified that the order is confined to cases falling under paragraph 30 of the judgment. It doesn't speak of any other demand. There can be demand arising out of other spheres, only in respect of paragraph 30 minutes. So therefore, my humble submission would be, so far as the limited language section 5 is couched, if your lordship will say, where a return, the dealer is required to file return under this section, fails without sufficient cause to pay the amount of tax due as per the return. Two things, lords. Tax due only emanating from the return itself, and there must coupled sufficient cause. And the interim order, if your lordship will find that I have been asked to pay 33.13 as in every monthly return which I file with the department. So therefore, perhaps there cannot be a better instance for my lords to kindly appreciate in the peculiarity of the circumstances and the order passed by Honorable Apex Court in these batch of cases. Unlike other matters, where there is stay of demand or stay of judgment, those are not there. Stay of notification, these are not there, mirrors. And one more thing I will submit, mirrors. There are constitution bench judgments my lords have come across, the Haryana Finance Corporation's case, Padma Sundar Rao's case, Oriental Bank of Commerce, all those cases, Honorable Apex Court said, this court only while following any judgment as precedent has to take into account whether the facts are identical with the matter your lordship is concerned. So, time FSI mirrors, whatever I said, these are not relevant. With great respect to my friend Mr. Dwivedi, the citations are not relevant in present context. This will be humble.
I have a minority view, my lord. In my case, two of my cases, the state has not preferred appeal before the Supreme Court. In different cases. Though I have got an order from the Honorable High Court, the state has not preferred appeal. And secondly, I have not shifted the burden onto my customers, and I have paid the tax from my pocket, my lord. Okay. And thirdly, my lord, 7.5 and 7.6, if your lordship may see, the almost similar provision. 7.6 is for penalty and 7.5 is for the interest. And 7.6 also says without reasonable cause.
and they have not imposed penalty because of the reasonable cause they have accepted. The same logic applies for 7.5 also, ma'am. And I'll file my separate written submission by tomorrow with regard to that fact that I have a separate case altogether. They have not preferred appeal in my case.
All right. Ms. Lakshmi Kumaran, did he reply to you or?
Yes, my lords, there was, I think, a reference to one of our judgments that we had cited on sufficient cause. So I wanted to rejoin on that, if I may be permitted. Yes. So, my lords, I think my senior had argued that the concept of sufficient cause, as cited in the Baswaraj case that I had cited, applies largely to the concept of limitation, and therefore the interpretative powers or the liberties that we have while interpreting a clause which allows you to file an appeal. Appeal being, if I heard it correctly, appeal being being a fundamental right, should be liberally construed. That is, your right to appeal should be liberally construed. So for this, I have two submissions on this point. And thereafter, I just want to highlight one point in my William Fernandez case for sufficient cause in my case. These are the two submissions I'll be making today. The judgment of Baswaraj was rendered in the context of filing of an appeal in a land acquisition matter. I think Section 54 of the Land Acquisition Act, etc. And the question was, were they prevented by sufficient cause in filing the appeal? Number one, appeal is not a fundamental right. It is a statutory right. There are judgments that have said that appeal is a creature of statute. You cannot claim the right to appeal as a fundamental right, for which I have a couple of judgments. I'm not reading them. Municipal Corporation of Delhi and others versus International Security, 2004-3 SEC 250 says this. There is no inherent right to appeal. Similarly, State of Haryana versus Maruti Udyog, 2007 SEC 348. So this is only on the proposition that appeal is also a statutory right. Okay. Again, coming back to the point that therefore it has to be interpreted as you would interpret any statutory provision. That is one point. Apart from that, I'm just projecting on the screen 4 or 5 other judgments. I'm just making a table. I'm not taking my lords through the judgments, but there are the tables. Disabled. Okay. If for Kunal Kapoor.
Yes, we are permitting you to share.
Yes, thank you. I'm so sorry. So these are judgments where, relying on Baswaraj, the concept of how without sufficient cause, or the phrase sufficient cause has to be interpreted in Baswaraj, has been applied in various other judgments. There is a judgment of Ramnath Sao versus Govardhan Sao, where it talks about sufficient cause for setting aside abatement of the suit and continuation and delay in substitution of the heirs in a suit. There is another judgment of Banarsi Das versus Dalmia Dadri.
I think that you already cited.
Yes, because that,
Punjab and Haryana.
yes. And that is in the context of removal of name of shareholders from the register. That is not a context of appeal. Then there are 3 more judgments. Surinder Singh Sibia, which is a case of rent control, where it was an application by a landlord to the controller seeking direction to the tenant to put him in position. And the proviso that they interpreted was that provided further that he has not vacated such a building without sufficient cause. Again, not in the context of limitation or appeal. Then there is a judgment of Sankaran Pillai versus VP Venu Guruswamy. Again, Section 11.4 of Tamil Nadu Buildings, Lease and Rent Control. Again, this is in the context of rent control, not in the context of appeal. So, and the last one, which is non-payment of maintenance issue under CRPC, Ajit Kumar versus Shema. I will put it in my submissions. We are facing some difficulty in putting this on the screen. Suffice it to say, therefore, Banarsi Das may have been in the context of appeal. Appeal, in any case, is not a fundamental right.
Suppose you were to substitute that expression without sufficient cause with the expression knowingly. Would the circumstance be different?
And just look at the section.
Knowingly fails. Suppose we had the word knowingly prefixed to the expression fails and there was no sufficient cause.
Where a dealer required to file return under this section fails.
Knowingly fails to pay the amount of tax. Would it make any difference?
Yes. Yes.
What difference?
The difference is the failure to pay. Is there a reason for failure to pay? If there is no reason, and the reason is something that the statute is recognizing.
In some of the judgments, why I asked is in some of the judgments, it seemed to indicate that the litigant took a risk. He went to the court, he took a risk. He knew whether he may not succeeded. He presumed he would succeed. It was like a gamble. He failed. Once you fail in your attempt at challenging a statute, you have to pay the consequences of such failure.
Yes.
Then you can't turn around and say, oh, no, I didn't know whether I would lose or not, and therefore I did not pay.
Absolutely.
That is the argument. I understood from those judgments, the argument that was sought to be advanced is all of you, when you went to the court, you knew that you only had a 50% chance of success. So you knowingly failed. So so you knowingly failed to pay. So which is why the argument was that mere pendency of a litigation will not supply sufficient costs. That's the main argument here.
In fact, my lords, my submission is whether you write the word knowingly or you remove the word without sufficient cause. That is, if the section reads, where a dealer required to file return under this section knowingly fails to pay the amount of tax, there is an aspect of motive that, yes, I am taking a risk. Yes. If the section were to read, where a dealer required to file return under this section fails to pay the amount of tax due, he is liable to pay. That is a simpliciter. That is, it is a per se, like in Competition Act, you have a per se violation. Cartel is a per se violation. You engage in this per se violation. That is a case of a per se. Knowingly is, yes, I know, and I will not. This is a risk that I am going to take. I am arresting my interest liability, which we see in many cases. You pay the pre-deposit or you pay the tax amount and then I arrest my interest. My interest will not increase after a particular date. So I arrest my interest liability. I'm knowingly taking that risk. But having said that, here the expression used is different. And the expression is fails without sufficient cause to pay the amount. Now, have I paid or have I failed to pay the tax? Yes. Because failure here is not attributed to wanting to pay, not wanting to pay, prevented to pay. No. Tax was to be deposited. I did not deposit. There is failure. We will look at it in English. Did I fail because there was a sufficient cause? Or did I fail because the cause which I cited for not payment, did I fail if that cause was sufficient or not? So therefore, when we talk about sufficiency of the cause, it has to be tested on the mantle of a bona fide or a genuine reason for failure to pay. So that is one submission I'm making. I don't know if I have managed to put over my point in the manner that I was.
No, there's one clue that was given to you by Mr. S.P. Mishra. All right. He said, what supplied me the sufficient cause is para 30.
Yes. Yes. I'm coming to
him. Yes. There is a distinction between actually succeeding in that risk taking, which all of you did before the High Court, and then again pushing yourselves into a risk position because of the 3rd February and those orders.
Yes. So I will just, in fact, that was the argument I wanted to take. I'm obliged and I thank my learned senior also.
If you logically take this forward, about this knowingly, today it's a very interesting situation. Let's say you succeed or lose before this bench. Next is probably even a review petition before this bench.
Right.
Then you go before the Supreme Court. You could lose or succeed in the Supreme Court. Then there is a review petition in the Supreme Court.
Yes.
Then there's a curative petition in the Supreme Court.
Yes.
Then there are IAs in those petitions. So there is no end. So a litigant can't plan enough.
Yes.
The litigation itself has become complex, stretched out. You can go on endlessly, and businessmen have to arrange their affairs.
In fact, on a slightly lighter note, my lords, my lords may remember while in Delhi High Court, my lords had delivered the judgment in Make My Trip, where a person was illegally detained, etc.
Correct.
That went to the Supreme Court.
Right.
And my lords had directed the refund of the entire amount that was coercively recovered.
Right.
That matter went to the Supreme Court. We did not get a refund. In fact, there was a stay, interim order passed in the Supreme Court saying that there will be stay of the order, and therefore they did not pay back the pre-deposit amount. Thereafter, the matter, they succeeded, and the revenues appeal got dismissed, in the SLP got dismissed, and the review petition was filed. Review petition also dismissed. In the middle, they granted refund only of the pre-deposit amount. They refused to grant refund of the interest. On the ground that no, this interest, we will calculate it later, adjudication is going on. All I'm trying to say is this today. That's a separate note, and I'm only highlighting the usual distress that litigants face and assessees face. It is not possible
but
to...
Mr. Divedi's point is state is also a litigant.
No, state may be a litigant.
The state is also a distressed litigant.
State is the biggest litigant. Be it union or the state, they have the highest
Mishra,
number.
The standing counsel here says, in my court, the state is the most distressed litigant.
It's very nice to hear to the other non-state litigants. We get few moments of...
add a few lines.
Yes.
A lordship would only visualize, according to my humble submission, who was before the Supreme Court. It was the state who was before the Supreme Court.
Yeah, that was the point.
My lord. And on 30th of September, it was state. What was state was para 30. The state was all the time litigating before the Supreme Court. And this 1/3, 2/3 order was to strike a balance, my lord, between the assessees and the state, my lords, and give the state 1/3, my lords. So the assessees were never before the Honorable Supreme Court. In fact, this 1/3, 2/3 was to the advantage of the state, not to the assessees, because it was in their interim applications. This order was passed, my lords.
All right.
I'll just tell you the last.
I have not finished, I think.
I'm sorry. I'm sorry.
I'm so sorry. No, I'm so sorry. Just 2-3 other points that I wanted to therefore reply. One is on the sufficient cost. According to me, the threshold is given in Banarsi Das and the judgments similar to Banarsi Das, which we have submitted already. The as my learned senior just pointed out, the state had gone arguing that the aspect of discrimination, if the goods are not manufactured within the state of Orissa, then you cannot levy entry tax on such goods. That was the point that because on compensatory, the High Court had held in their favor. But on this point, they had gone out in appeal to the Supreme Court. Now, this is the point. Today, there is an additional point on discrimination, which in Justice Bhanumati's portion of the 9-judge bench decision, which is on equalization of the burden. That happens in states like Tamil Nadu, in Andhra Pradesh, in Gujarat, etc., where a credit mechanism is given. That is, I may be bringing goods from outside the state of Orissa into Orissa. Local dealers are also suffering entry tax, but local dealers are given the benefit of credit between entry tax and VAT. So that flows seamlessly. When I'm coming from outside the state, if I'm bringing goods from outside the state, I have not paid VAT, I do not get that benefit. That portion, that portion conceptually has been raised, not decided, because they said individual states will. And in fact, on that portion, there is a batch of matters pending.
Correct.
Even in this, that Unitech matter, that is also pending. So that is only to say that till even today, on that aspect, there is no quietus. So if one has to take the argument of sufficient cost even further, I can argue. I am not pressing that point. The last point which I want to make is peculiar facts in my case, which is while... I'm sorry. Yes. The very last point which I wanted to make, which is a peculiar facts in my case, which is that both the state of Orissa versus Reliance and the Bharti Airtel judgments in the Supreme Court, which was the division bench of the Supreme Court, came on 28th and 29th of March 2017. However, so there were 3 batches of matters, writ petitions that had gone from Orissa. There were 3 batches pending in the Honorable Supreme Court. 2 of those got disposed of in March. The last batch got disposed of in October 2017. Now, my matter got disposed of in October 2017. Now, it is not that it is one stray matter that got dismissed or that got disposed of in October. It was a batch of matters, and State of Orissa has made substantive arguments even in that. I'll read one paragraph alone. Learned counsel appearing for various, if I may, just because this is important, only to show that it was a substantive argument even in October 2017. So, learned counsel appearing for various petitioners relating to civil appeals from the state of Orissa, in the end, has sought for liberty from this court to urge grounds of discrimination under Article 304A of the Constitution of India. Then, learned counsel appearing for state of Orissa has opposed the prayer of petitioner seeking liberty to raise this issue. It is contended that petitioners have not raised the relevant issue nor pleaded it in the support of the discrimination under 304A. The parameters under which entry tax can violate are given, violate Article 304 has now been conclusively laid down by the 9 judges. We are of the view that liberty be given to the petitioners to raise the plea of discrimination. That is, if not for this judgment of William Fernandez, for these batch of petitioners, we would not have got the liberty to raise this plea on discrimination. Which is why, for me and other similarly placed assessees who were pending, and this was a case where assessee, I had gone in appeal in SLP. This was not a case where revenue went. In my case, I had also gone on the aspect that it was it was held to be compensatory, etc. So I had gone in an SLP in this case, and I have now been given a liberty to urge the point on discrimination only qua me in para 144, 145 of William Fernandez judgment in October 2017. So, according to me, qua me, my sufficiency, and until this date, the stay was in operation in my favor. That is, I had, in whosever favor, I think now we don't know in whose favor that stay was operating. Nobody seems to be happy with the stay. But there was a stay which prevented me till that date. I wouldn't want to say, it gave me sufficient cause to believe that till October 2017, I do not need to pay the balance 2/3 amount. I waited till October 2017 to say, okay, now I will pay the balance 2/3 amount, because I very well wanted to urge. What was happening was petitioners were urging the point on discrimination.
So in your case, you want to contend that between 28th March and October 2017, for those 6 months,
yes,
you're not liable to pay interest.
I'm not liable to pay interest.
All right, all right. I think they'll reply to that separately. I'm sure they'll file a separate note for that. All right. All right. All right.
I am left out, my lord.
I'll just, before my lord senior begins.
I have been left out.
No, not at all, sir. How can you ever be? Right.
The last item, which is WPC 34659.
Yes.
I have a similar problem.
Yes.
That my case was disposed of along with Father Williams
Yes.
on 9th of October 2017.
Similar point.
Similar point.
Right.
And if your lordship would have, for sufficient cause, your lordships have said that purposely.
We're just playing with words. This is all semantics. So trying to understand the word.
I'll just repeat, my lords.
So it's the old technique When you have a word, see what is the opposite of that word.
The state was all the time.
And ask if this is really opposite of that.
The state was all the time taking a risk, not the petitioners.
Right.
And the state was getting the benefit of 1/3.
Okay, let's see if I just want to clarify. Just
No, if all of you knew how the state litigates, then you knew the risk. But the state will never stop with one adverse judgment.
Because we had your lordship judgment para 30 with our
As said by Mr. Nandi Palkiwala, the state is the largest litigant.
Maybe.
I have just filed a written list of dates in the last
lesson, that book, yes, mentioned it.
I just want to
So
clarify
I've
one
given
line.
put a second, sir. I've given a list of dates in WPC 34659. I've already submitted that.
All right. Yes.
I just want to clarify one line, Your Lordship, not regarding submission only. So far as these two cases are concerned, actually these two cases are connected with that para 30. But Your Lordship inadvertently has been tagged with that matter. So William Fernandez matter. So in these two matters, I may
No, that inadvertently, I mean, they still can legitimately say
till October, we did not. I'm not denying, but what I'm submitting only that these two cases are connected with para 30.
Right.
So, but inadvertently have not been disposed of, and those have been tagged with William Fernandez and disposed of along with that batch. Even though imported goods is not the issue in that two cases. Your Lordship.
All right.
My list of dates may kindly be taken.
Right.
Due respect to my learned senior Dubedi ji, my lords, here the word is due and payable as is occurring under section 7. And the third one is sufficient cause. My lords, due is the moment the dealer files his return, admits his liability malus. And it doesn't become automatically payable as long as it is ascertainable by the assessing officer. There has to be an ascertainment. Charging section is section 3 malus. Subsection 5 to section 7 uses the word sufficient cause. Could not be return, could not be filed, or the tax could not be paid. And similar language you also will find in subsection 6 to section 7. The same thing is there, sufficient cause. And subsection 7 also repeats the same thing as sufficient cause. Now this word sufficient cause also also will find under the CST Orissa rules, that same word is there, where the dealer fails to file the declaration forms. Then Lordship have recently decided also a judgment in my case that penal interest, section 8A, Indira Leather's case, my lords. They are also.
But interest is leviable. Penalty is so far as sufficient.
Let me complete you. Who was there? My lords, they will not allow Mr. Misra along with Mr. Pradhan. Let me complete.
Yes.
Why you are so anxious? You have already owned in the Supreme Court. Why you are so much ballots? A judgment came before this Honorable Supreme Court in Associated Cement Company Limited versus State of Rajasthan. That is my lords, they don't judgment. Before 3 judges bench of the Honorable Supreme Court, Justice Bhagwati was the minority view taken, and 2 view was taken by Justice Venkatramaya and AP Sen. The majority view was expressed by Justice Venkatramaya. Well, there the case was, first is page 1 to 32, my lords will find. There what happened, my lords, freight charges was not included
initially the dealers therein did not include freight charges on the sale price while selling. Relying on the judgment of the Supreme Court in Hyderabad asbestos case, my lords. Later on, my lord, Supreme Court delivered a judgment in Hindustan Sugar Limited versus State of Rajasthan. Immediately after the judgment, the dealer started filing revised return, and also included, while revising the return, they included, my lords, the freight charges, the transport charges on the sale price. Now, interest was levied under Section 11B of the Rajasthan Sale Tax Act. Then matter came before the High Court. They didn't succeed. Matter came to the Supreme Court. In the Supreme Court, Justice Bhagwati, the minority view took, said that the moment you are saying that the liability, it doesn't make you payable. And interestingly, under the Rajasthan Act, there was no sufficient cause.
Correct. Simple failure.
Say. And Justice Venkatrami and AP Sen, they did not agree. Rather, Justice Bhagwati dissented from it.
No, this is very similar to the Calcutta Jute
Yes.
Yeah.
Yes.
It's very similar to that. Yes.
Then, my lords, and just Lords may give me another just 3 minutes.
Yes.
Then it was well explained by a 5-judges bench. That is JK Synthetics Limited versus Commercial Tax Officer.
Correct, correct.
There, the Justice Ahmadi delivered the constitutional bench. The author of the constitutional bench was delivered by Justice Ahmadi. And the constitutional bench, my lords, overruled
correct
the majority view
in associated.
That means the view taken, my lords, that what I have, that due and payable, tax becomes due. All right. Now here, my lords, when prior to 2009, 2008, the Reliance judgment was pronounced by this Honorable Court, and a part of it was struck down.
Right.
Now the dealer as well as the state went to the Supreme Court, my lords.
Right.
The Supreme Court initially said you pay the amount by September 2009.
Right.
Then, my lords, again there was some grievance among the dealers. Then the order, they wanted to modify it, and they modified ultimately, I think, February 2010. And the matter how it was left before the referred to the larger or the constitutional bench, that is a different thing. But the order was modified, saying that 1/3 amount you deposit, 2/3 amount will be kept in abeyance, and that will be treated as a deposit. That is an admitted position. Not only, my lords, in Supreme Court, following this order also, the Commissioner of Commercial Tax has also did issue a circular in 2013. Rudro? 2013, a circular was also issued by the Commissioner saying that, of course, at the instance of the court time and again, at that time, Chief Justice Goyal was there, and Justice A.K. Rath was sitting, and I was the arguing counsel for the petitioner. You know, all the time we are dealing with this 1/3, 2/3, what is this? Then he asked, and the standing counsel, as he was then, he was asked to ask the circular. I think Mr. Kaur was there, this as standing counsel. He was asked to communicate the grievance, of the court, and he communicated it. And thereafter, the commission issued a circular. No, from now, you pay this 1/3, 2/3 will be kept in abeyance. Before that also, my lords, many division benches at different time, many different division benches also said, you pay 1/3, 2/3 be kept in abeyance. What my effort is that, my lords, with great respect to my learned senior, Mr. Dwivedi, my lords, this is a case of sufficient cause. It is not that of the assess's volition. It is not necessary. Sufficient cause has not been defined under the Act. From the events, as your lordship knows, cause of action, a bundle of facts which give rise to the relief are prayed for, isn't it? So that is what is a sufficient cause. It must be a bundle of facts which must be put together, must say that yes, this is the cause for which I could not pay the tax. And it became, when it became payable, my lords, it became payable on the debt, and it is not, that will be speculative. But the dealer cannot assume that, okay, a judgment will come against me. So immediately he will make the funds ready. All right, the judgment tomorrow is going to be delivered. They are going to give the judgment against me. Let me pay it. It's not like that. It's beyond everybody's imagination. So, my lords, when the judgment came, the assessing officer issued the notice under E32, E34, E24, all these forms were used, mechanism under these are all the mechanism, procedural in nature, they issued, and some of the dealers did make payment, did pay the amount, and some of the dealers made application to the commissioner saying that I'll pay and with interest. The balance 2/3 amount with interest will be payable. So, my lords, my respectful submission is that not from the date of filing of the return, but from the date of the judgment of the Honorable Supreme Court delivered on 28th of March, 2017, my lords, it is payable. That is what Justice Bhekar has said. No, the judgment of Hindustan Sugar will not, cannot say the liability from that day. That view, Justice Bhagwati, my lords, will read that judgment, said that then that will be a contradictory stand. And that view of Justice Bhagwati has been upheld by the larger bench, and where State of Rajasthan versus Ghasila, the constitutional bench judgment delivered by Justice Sikri, that is, my lords, year 65 Supreme Court, as third one I have given, this judgment was relied on by Justice Bhagwati. And Justice Bhekar said, but Bhagwati is not correct in relying on this judgment. That dealt with penalty. This is interest. So in one line, he dissented. And later on, the JK Synthetics and also Billa, Billa Cotton, their my lords, they said, no, Ghasilal case is the correct case. Whereas Saigal case, which was relied on by the Venkatramaya, was not accepted by the Constitutional Bench. So, my lords, I want to conclude, my lords, none of the liability, although existed, but became payable only from the date of the judgment of the Supreme Court, where it is said that it is payable. Of course, it should have been ascertained by the assessing officer and with a demand notice, because assessment is also a part of the procedure. First is the incidence of tax, that is section 3, where the tax is imposable. The second is the assessment, and the third is recovery. And all the courts said the charging of interest, although is procedural, but it is substance in law, substantial, substance. And therefore, mallards, it is the procedural law mallards should be given so as to give effectuate the charging section so that no one escapes his liability. These are all mallards. And with great respect to my learned senior, Mr. Dwivedi ji, all the decisions he has cited regarding this unjust enrichment and all the things, so as to press his argument that it is there is no, sufficient cause. None of the judgment, my lord, dealt with any word sufficient cause. Whereas in Orissa Anti-Tax Act, Orissa CST, Orissa rules, there the word sufficient cause. And as a matter of repetition, I will just detain your lordships for 2 minutes, as your lordships danger time is coming. My lords, Mr. Chima is not there, my lords. My lords, he's there. No. My lords, all these things, my lords, that sufficient cause is only used. My lords, take for example also under the Income Tax Act, my lords, when the advance tax is not paid, that is 215, then there must be a sufficient cause to waive 234A, 234B, 234C, where the commissioner is empowered, chief principal, chief commissioner is empowered to waive that. So that sufficient cause is a bundle of facts, which must be, the court should also visualize so as to come to a decision what prevented in not paying the amount immediately.
All right.
Well, thank you, madam.
Just one.
Mr. Malti, do you want to say something, Mr. B.K. Malti?
One moment. So I'm appearing for WPC number 6281 of 2020.
Yes.
I wanted to tell your lordship that there is another division, because the goods which are manufactured inside the state would be subject to entry tax.
Right.
Goods which are not manufactured in the state, by virtue of para 30, will not be assessed to tax.
Yes.
So my client all comes within that 130 para 30 as well as non-para 30. So I have paid all that amount as non-para 30 and paid 1/3 of it, and I have filed my returns. They are at page 39 to show that there I have said that because they have made this, you have to pay it through the computer will not take it unless you say that by 1/3 is so much by virtue of the judgment of the Supreme Court. Now the question is that all of them say that not payable. But question is that could you have demanded, because there is a methodology of demanding, this is under E22, subrule Rule 10, subrule 5, clause C, that where 7.5 is not paid, you are required to issue a notice under E22. The lordship got it?
Yes. Right. 10.5 A. Yeah. Failure
So
to
therefore, all this time, as long as the matter was pending in the Supreme Court and you are enjoying the benefit of 1/3 collection, you were satisfied, and therefore you never issued an E22 notice. My lord, am I clear?
Right, right.
So therefore, you understood that this amount is not paid. I understood that this amount is not paid. So the question comes on the sufficiency of costs. Now, I cited the section 271(1)(a) of the Income Tax Act, which said the exact language, but for penalty. So there is 271(1)(a), B, C. C is regard the suppression. So they said suppression is mens rea, and 271(1)(a), they had explained it, how it will be treated. Failure to file a return implies a decision to omit or to do an act rather than doing a positive act. Omission to file return total income presupposes the obligation to file it. The assessee may not have been conscious of the obligation, but failure to file and will believe the absence of an obligation to file has to be distinguished from the case of failure to file within the required time where there is knowledge and obligation to file. Now, how they will be discharged? When there is an obligation to file, the failure to file or delay in filing depends on the decision not to file or to file within time. When a decision not to file or not to file within the required time is taken, it may be reasonable cause or without any reasonable cause. Assessee have failed to file a return on bona fide belief that he is not required to file such a return may be treated as a reasonable cause, and it may be distinguished from that assessee who filed return earlier or certain about the obligation and didn't file later. Now look,
All right.
I have given my first day's note in para 19 and 20. The burden will shift and how they will be discharged.
Right.
That is all.
All right. All right.
Would you permit my-
Your Lordship, may just add there's another matter which was also disposed of along with Father Williams. I'll give the other two matters. There's WPC 1061 of 2018, Mrs. Imami Paper Mills, my lord. That came to be disposed of along with Father Williams in the month of October.
All right.
Yes, sir. Your Lordship, close the matter. WPC number 3529 of 2018, that is to delete from dispatch. Your Lordship have directed in the other connected matter by judicial order to delete, but it has come. I am giving a copy of my Lord's order.
How is it still come? Today will be reserve orders. It should not include this. We've already passed an order dealing with
The Tata Steel case, the other day your Lordship have dealing along with that.
Right.
My Lord. That's why kindly delete.
The order is there. He's giving a copy.
Then
So why is it still shown this back? Right.
3529 of 2018, my Lord.
All right. All right.
Would you permit, I would like, well,
Yes,
just-
yes, sir.
I have got
Can file financial notes.
I have got some points. Just I want to add some points. Included the arguments. Well, what I would like to point out here, all of us have dealt about sufficient cause. Sufficient cause also emanates from the Limitation Act under Section 60, Section 5 of the Limitation Act. Your Lordship may kindly see, so far as there are three criteria. These cases which we have come up before your Lordships, virtue of the High Court order interim protection, we were protected, not before the apex court. Your Lordship will see that the stand has been taken under Article 141. Any law declared by the Supreme Court shall be binding on all courts within the territory of India. The interim order which has been passed by this Honorable Court has taken into consideration the apex court interim order and direction has been passed. So we were protected. So that has also been reflected in the interim order passed by this Honorable Court. Your Lordship may kindly see.
No, we've seen all that, sir.
That,
We've
yes,
been
that
shown all
again-
these bunches. Yeah. it's okay.
For the purpose of Article 141, once it is binding, we were restrained from depositing our tax so far as we are concerned. Well, your Lordship will see in this contest, one of the judgment of the Honorable Apex Court, which has recently come. That is 2023 Supreme Court 9 live law, civil appeal number 1669 of 2020, decided on January 4th of 2023, Sabarmati Gas Limited versus Saha Alloys Limited. There, their lordship was taking into consideration Section 5 of the Limitation Act, and for which with the Insolvency and Bankruptcy Code, vis-a-vis the Sikh Industrial Undertakings Act, they said under Section 22(1), there was a limitation with regard to approaching the court because they were barred, statutorily barred. And for condonation of the delay portion, one part was decided by the Honorable Apex Court, which I'll take your lordship to paragraph 25 only I will place for the purpose of condonation of what is sufficient cause. That as relates Section 5 of the Limitation Act.
Mr. Rathar, just be a bit kind to us, sir. Do you have a copy of the judgment, sir?
But I'll be supplying that.
Then whenever you find time, you put it in your notes, sir. Because without having a copy of the judgment with us, it will be difficult for us to follow what you're saying. You put it in your note. You put it in your note. We understand you did not have time to make photocopies. We understand all that. You just put it in a note. All right.
That I will do. That I will do.
Anyone else you wanted to argue?
No, my
Yes.
lords, not argue, my lords. My lord, serial number 3, my lords.
Yes.
13573.
Yes.
My lord, this matter doesn't relate to interest.
All right.
My lord, there's no interest demand. There's only a penalty demand.
Okay.
So it has been tagged on to this. It may be taken.
All right. We'll take it off.
My lord, send your lordships, my lord. Before this 3rd February order, 3rd February 2010 order, where the directed to pay, Supreme Court directed to pay 1/3 of the tax amount. Before that, on 8th of December 2009, the Supreme Court had directed the state government, directed all the assessees to file returns, and that they directed the state government to compute the tax demand and pass assessment orders so that the liability is fixed. And then they passed on 3rd of February 2010, they passed that 1/3 order. Lords, I'll file that order itself, 8th of December, lordships can go through.
All right.
We permitted to file compilation tomorrow or Monday as well.
Yeah.
File.
These are all parties are permitted to file further notes of submissions, compilations, judgments within 1 week. All right. Orders result. All right.
Okay.
Because could we have time
This
to
matter, to give a date. You say D-link from, which is that matter? What is it? Is it part of some batch? This 13573?
No, my lord. This was in a near
list on
an individual
11th September in the regular list.
just kindly give us 3 days time after the petitioners have filed the submission. Because
So then what might happen, Mr. Dwivedi, is again they will want to file a reply to that. Once they file a reply to your submission, you will want to file a reply. There will be no end to it, Mr. Dwivedi. All of you file it within 10 days. If you want 10 days, you give 10 days.
No, it's already 7 days is good.
No, she's orders.
Grateful one. Grateful.
All right.
Your Lordship, just one line, so far the factual, Your Lordship, so far as Mr. Rai's.
You put it all in a note, sir. Whatever you want to say, you put in a note. All right.
Weekly list. Item number 131.
Are grateful for the patient hearing.
May I proceed? Well, the petitioner is the outclass steel plant challenging award passed by the presiding officer, my lord. The reference was made in the year 1996. The lordship permitted me to reference, my lord. reference, my lord, whether the demand of the union to pay the equal pay to contract workers for the similar and equal nature of job and to regularize their services in the line with the regular workmen of the Purnapani limestone dolomite quarry, my lord. The dolomite quarry was closed in view of the notification dated 2003, my lord. The contractor was applied under 25Q of the application, my lord, for closure of the establishment. And the establishment was closed in the year 2003, my lord. In the year 2015, my lord, the London Industrial Tribunal directed to reinstate the workmen. The workmen are saying in their written statement that the 15 numbers of workmen are not paid their retrenchment benefits, my lord. After the closure, my lord. The written statement was filed in the year 2008, my lord, and closure in the year 2003. And closure was granted on the under section 25O of the Act applied by the contractor, my lord. And the union was set ex parte. The reference was to regularize the services of the contract laborers, and the order of the tribunal, my lord, to regularize them from the date of the hour. The mines was closed since 2003 in view of the notification under Annex 4 series, my lord. The permitted, my lord, Annex 4 series, my lord. The application is at page 73 under section 25O of the Act. The application was made on 21st November 2002 and with effect from the closure was 28/2/2003, my lord. And in the written statement, the management has stated the establishment has closed since 2003, my lord. And in the written statement of the workmen, they have stated in para 12 is at page 60, my lord, my repetition, my lord, the about 50 contract workmen who have been added as parties after such struggle are now waiting there for redressment claims, my lord. The application was made by the authority on 25O and the permission was granted under Annex 4 series, my lord.
My lord, order number 7 may kindly be seen, dated 16/12/2022. Lord, an IA has been filed, IA number 14040 of 2022, praying for addition of parties of workmen. In the lower court CGIT, the workmen were added as parties, but in this rate petition, the workmen are not added as the parties.
Oh, they're not been added?
No.
Oh, I see. You filed an IA?
Yes, your lordship.
What's the IA number?
IA number 14040 of 2022.
Oh. Okay. IA 14040. This is an application by the workmen who are all parties before the Industrial Tribunal, Central Government Industrial Tribunal. In ID case number 24 of 2001. But for some reason have not been made parties in the present petition filed by the management challenging the award passed in the above case. Full stop. For the reason stated, the application is allowed and the applicants are added as opposite parties 5 to 66 in the writ petition. The consolidated cost title, has it already been filed? No.
Now I have filed.
We filed within a week.
My lord. Today I am filed before this court.
It's taken on record. All right. In the main writ petition, you've got a copy.
Yes, your lordship.
Ah.
My lord. My lord, the page 60 of the petition, my lord.
Yes.
Page 60, paragraph 12, my lord.
Yes.
It was filed after the closure of the establishment in year 2008, my lord. The statement of claim filed by the newly added opposition parties in the year 2008, my lord, 26 June 2008. In the written statement, they have stated, my lord, para 12, that as on 1893, knowledge of the present workmen, their 2 and 5 feet of contractors are working, and in the meantime, something dead over and VRS. The pressure of man, and though the contractors now few for 50, about 50 contract workers who have been added as the parties. My lord, they have already added as party. And the in our written statement, my lord, filed by the management, page
para 18, para 15 and para
Right
18.
now, are you people still working there?
No, your lordship, most of them have been retired.
How many people are left?
Most probably 30 to 40.
Do you know that exact number, sir? Don't
No,
say
your
most
lordship.
probably.
I have to take instruction about
Please
that.
do that. Let's see. Let's understand how many workmen we're dealing with.
Yes, sir.
Is any of them still working with you?
No, man, since 2003, they all are not working.
So, conflicting statements. He says nobody's working. You're
You
saying
have to
somebody.
take instruction, my lord.
Contract goes.
After that application, the main matter, you say, while counsel for the petitioner contends that none of the workmen are continuing with the management, counsel for the workmen is uncertain. Full stop. Both counsels seek time to ascertain the correct factual position and file their respective affidavits specific to this issue before the next date. List in the roster bench. List in the regular bench, whatever, regular list on 5th July.
Weekly list item 132.
The details property have been enclosed. The petitioner has approached the Commissioner for Endowment and also the Law Secretary on the arrests of 4 and 5 million. Since no step have been taken to evict those persons.
Only one person. No, where is those persons' names are not there.
Pardon, my lord?
Just come to your cause title.
Okay.
Those encroachers are not named.
No, encroacher has not
So you file a better petition. Counsel the petitioner seeks leave to withdraw the present petition with liberty to file a better petition in accordance with law. Disposed of is withdrawn with liberty spread.
If your lordship will direct, my lord, let them conduct an inquiry, my lord.
No, but against whom? Unless the names are there, we can't just pass something behind their back. Then they'll come challenging it. All right.
Item 133.
None appears dismissed.
Weekly list item 134.
None appears dismissed.
Weekly list item 135.
None appears dismissed.
Weekly list item 136.
My lord, 135 million. Item 135. My lord, on behalf of my learned senior BP Tripathi Miller, my lord, similar case in this is the tagged and disposed of Miller. Then likely.
All right. All right. Same order.
136.
May please your lordship, for the matter relating that OGLS matter, here I am for the petitioner, my lord. One of my friend advocate of this bar, Mr. Suryakandas, he has filed 2 IA for intervention. His presence is very much required, but due to some personal difficulty, he has
Stay on board. All right.
I pray Monday.
Stay on board, sir. Yes.
Okay, my lord.
Item 137.
Item 37, I am for the opposite party.
All right. None appears the petitioner dismissed.
Meanwhile, the account is closed, my lord. They have settled the.
All right. It's stated that the account has also been closed. All right.
Item number 138.
None appears dismissed.
Item 139.
Same order.
Item number 140.
140, your lordship. This matter relates to grant of lease, my lords. The petitioner approached the Tahsildar, my lords, for grant of lease. And after following the due procedure, my lords, the Tahsildar recommended its case to the sub-collector for grant of lease, and the sub-collector put the record before the collector, Kalahandi, for grant of lease. And it is still pending. Your lordship, can I glance to page 14, my lords, of the brief? In the last para, my lords, in the master plan as revised, the land is reserved for industrial purpose. Hence, there would be no difficulty to lease out the area to Sri Akhil, the petitioner, for his proposed industry on payment of premium, ground rent, etc. As access.
The company of prayer clause, page 7.
Page 7, my lords.
Millers.
Read it.
Prayer. The petition that President Lordship may please to consider the fact that admit this application, call for the records, and after hearing the parties, the opposite parties may kindly direct it not to demolish the building of the petitioner standing over plot number so and so till disposal of the revenue case number 60 of 1983 pending for the collector regarding sanction of lease.
This revenue case 60 of 83 is pending for the last
Yes, your lordship.
30 years,
Yes,
40
your
years,
Millers.
40 years.
It is still
Impossible, sir.
pending. It is
Impossible.
still pending, Millers.
Can you find out? Collectors have cases which are 40 years old. He says revenue case 60 of 1983 is pending.
Item 140, last item.
140, yes.
Which collector is this?
Kodahandi, your lordship.
Can you just find out? Let it stay on board. All right. Over.